But I beg to mention item 24 and 25, madam.
24 and 35.
Yes, madam. I do not like to praise this petition, madam.
You want to withdraw this? You want to withdraw this petition?
Yes, madam.
The SK Mathil, Learned Counsel for the petitioner, submits that the petitioner is not willing to pursue this matter, and as such, the same may be closed. Accordingly, taking note of the submission of submitted article. Contact case number 12, so WPC number 12, that's closed.
My lord, liberty may be if required, my lord. If in future, madam, liberty may be required. Granted. Deadline may be, if required. madam. For the vaccine.
Liberty will remain with the petitioner to approach this court again by filing a.
Fine, fine.
Well, item 24, I am appearing for the respondent, my lord. And item 25, I am appearing for respondent 6, 7, and 8.
Sir, your name, please. Your name, please.
Yes, sir. My name is yes.
For respondent number,
Respondent in content case, respondent only respondent. And it petition 6, 7, and 8.
okay. Secret.
Like.
May I please, your lordship?
Yes.
I beg to mention for an unlisted motion, your lordship. Matter is very urgent. Suspension matter, your lordship. After three months has elapsed, he has got nothing, your lordship. The subsistence allowance also not given. He is in a distress condition, your lordship.
When do you want?
So, matter will move on today, your lordship. I have submitted the already.
Today there is one reference.
My lord, last item, if
Sorry.
if I am able to move, your lordship,
Sorry,
my lord,
next working day.
a date may be given, your lordship, on 22.
Got it.
Awesome.
May please, madam, prayer for listing of the petition matter. That's why your lordship submitted.
Admission matter, November 1st week.
November
Take it there.
November.
Please, your lordship. I have to mention for listing one, the petition, lordship, because the petitioner is going to retire very soon, lordship. So can it be on 22nd or 23?
The last week of October, 29th.
Obliged.
May I please, your lordship? Your lordship praying for requisition in item number 36. Affidavit in opposition, your lordship. May be allowed here.
Okay.
Obliged.
I am praying for listing for admission, madam. On Friday, madam, next Friday.
Wait,
On next Friday, 24th.
next Friday.
Next Friday.
Lordship, I am praying for listing of admission, Lordship, admission matter, Lord.
First week of November, take it that one.
May I please, your lordship, regarding item number 14, kindly fix the matter after 1 week. Actually, we have.
I'm appearing for petitioner lot. They inform me that they will file everything today itself.
Yes, yes.
There is a time for that only fixed time. What in but
Okay. Well, when can we fix the matter?
After 1 week.
next week lot.
Next week. Okay, as agreed by learned advocate of both the parties, let's place the matter on. That is that.
On 29th October.
May please.
File everything. That for 3 days, the last 3 occasions they have taken time for everything.
Okay. Pardon, sir, copy one. Okay.
Maybe I beg to mention about listing, my lord. It was listed, my lord, 9/8/2025. That was the, my lord, left or my lord. But petition is suspension, my lord. So on 22 or 24, my lord.
Last week,
My lord.
Last week of
last week of November. 28th. Sorry, 28th October.
May I please lordship, here for lordship 2 matters lordship for admission, sanction matter lordship. Next week any date lordship.
next week, only 3 working days are there.
34th.
Already we have fixed a lot of cases. Last week of October,
Last week of
choose
October.
any date from it.
On 31st.
May please, your Lordship, I beg to mention item number 15, Lordship. I have taken the consent of the other set. Kindly the matter will be taken on first week of November, Lordship. Any date may be fixed, Lord.
Item number 15,
15, Lordship.
Mr.
PK Basu.
P.K. Basu, learned counsel for the petitioner with consent of the other side, rest of its matter. Sir, Last week.
First week of November, any date.
Last week of November,
First week.
7th November.
Obliged.
Yes.
WPC number 120 of 23.
Pardon?
Matter, this matter WPC, this matter is related to promotion of the petitioner, and he will be retired on 31st October.
When do you want?
I want to mention that I kindly fix the matter on 22nd October before retirement.
22nd, not 40th. Next week. Okay,
30 October.
Yes.
May I please, your lordship, I beg to mention two writ petition, to be listed in the orders column, lordship. Last,
What do you want?
lordship, 23rd. Then
Next
in the
week.
last week, lordship,
Next, last week.
of this month.
28.
May I please your lordship?
Obliged.
Lordship, may I make a prayer for the listing of a matter in admission column? This is a very old matter. The arrear salaries has not been released since 2005. And it is the matter pertaining to year 2019, yet the respondents have failed to file their counter affidavit, lordship. Kindly fix this on 29th of October.
May
Deeply
I please,
obliged.
your lordship, I want to, listing for a matter for admission for next week. Listing a
Next
matter,
week, not 40th. Last week,
next week,
last week of October.
On 31st.
31st.
Yes.
May I please, your lordship, I beg to mention item number 36, your lordship, for adjournment, your lordship.
36 for adjournment.
Yes, your lordship.
You inform the other side.
Your lordship, I informed them, but they asked to inform them again if you allow it. They asked for requisition, your lordship.
Yes.
So your lordship, engaging counsel, Mr. Anish Parvi is not well today, your lordship. So you may not be able to appear.
Okay. Is your name please?
As they,
Lordship,
Learned counsel appearing.
I am appearing in item number 36, your lordship. I am for the petitioner side, your lordship. Lordship, there is urgency for hearing this matter, your lordship.
The counsel is.
Yes, lordship, that is why, lordship, can it be posted, a fixed date may be given, your lordship.
Last week,
Any date, your lordship.
last week of October.
30.
As
Right.
agreed by learned advocates of both sides, let's consider the matter 38 of.
Like,
May I please, your lordship? Lordship, I beg to mention for listing two repetition, my lord. One is for admission column, another is for my lord orders column. Last week, my lord.
Take a share.
May I please, lordship? 28 and 30. 28 and 30. 29 and 30. Okay. Must please, lordship. Lordship, with regard to item number 29 of the today's daily list, we have filed one IA, that only falls off. We have filed one IA, lordship. Today,
29.
item number 29, lordship.
Yes. Now?
We have, that may be false for lordship. Okay. I love.
May I lordship? May I lordship, bring for listing one motion matter lordship and two admission matter lordship, kindly, sir. Last week lordship, it was,
Also, next week, last week.
yes, lordship.
Okay.
Obliged,
Take
lordship.
it.
may I please, your lordship? Lordship, I beg to mention two writ petitions for admissions. These are great pay matters, lordship.
When?
Next week,
Next week, not also last week. Take it.
Also, I beg to mention for listing for orders, the petition, after vacation, maybe after vacation, that may be after.
Last week. Take any date from.
May please, the lordship. Lordship, I am saying to upgrade item 42 at 2, my lord.
Pardon?
Item 42, can it be taken up at 2, my lord? Because, my lord, in that consent application, my lord, given last opportunity today to comply the order, my lord.
2 p.m.
At 2.
Okay.
Wait, please,
I am deeply.
lordship, I beg to, with the due consent of the other side, I beg to mention item number 12 and 13, my lord. In this matter, we were supposed to file our affidavit, my lord. However, my lord, the adequate instruction was not received, so we have again written to the department to send us the adequate instruction, my lord. Therefore, my lord, I pray, my lord, the matter may be taken up after 10 days, sir. I have taken the consent of the other side.
So if learned counsel for the
Respondents.
the next counsel for the. In the case is consent with the right for the matter after 10 days.
May I please, your lordship? I beg to mention for listing two matters, lordship, regarding pertains to area salary and the pensioner benefit of the petition. The 28th or 20.
Last week of October, take it there.
On 31st October.
Look.
For motion item number 1,
May I please, Lordship?
Yes.
Lordship, the petitioner earlier approached this Honorable High Court, and the Honorable Court has passed an order with a direction. Lordship may kindly come to page number 25. Para 12, second part. This court does find that the ends of justice would be met if, without going to the merits of the case, the writ petition is disposed of at the motion stage by directing the responding authorities to consider and dispose of the representation submitted by the petitioners dated 9 July 2025 with a speaking order by adhering to the principles of natural justice and fair play within a period of 3 weeks from the date of receiving a certified copy of this order. Copy of the writ petition may also be enclosed for the perusal of the respondent authorities. And now, Lordship,
Sir, your name, please.
page number 25.
Your name, please.
My name is Vikas Hazarika.
Learned and counsel for the petitioner. This application under section 11 and 12 of section under section 11 and 12 of Contempt of Court Act 1971 related to Article 250 of the Constitution. Yeah. For willful and disobedience. Willful disobedience of the order dated 22nd of August 2025 passed by this court in WBC number 4,831 of 2025. Peruse the application in the document plus record and also peruse the order dated 22nd of August 2025. That notice be issued to the respondent contempt of returnable in for which the fee taken by registered post with AD and also by usual process within a week from today. There is the matter after 4 weeks.
so item number 2,
May I please, Lordship? Lordship, the matter is non-payment of petitioner salary. On the last occasion, this court was directed to produce information instruction by the government. Lordship, kindly see the earlier order dated 15 September.
Anybody for elementary education department? So what instruction is available with you?
No instruction, Lordship.
Pardon?
Instruction, Lordship. I have no instruction, Lordship.
No, there was a direction to obtain instruction. About 1 month back.
Actually, Lordship, someone other was attached with this matter, Lordship. As there is no one is present in this court, Lordship, so that I am appealing for another behalf, Lordship. Being an elementary semi council.
Whether Ms. Pupone is available in the court today.
No, Lordship. No,
Pardon?
Lordship. No, Lordship. Please, yet to reach the court, Lordship. Yet to reach, Lordship.
Yes. So you do one thing, you obtain instruction why the salary of the petitioner has
Okay.
not been paid.
Lordship.
We'll take it up after some time.
Lordship.
Item 3.
Also been spent on the earlier occasion, your also maintainability of the petition was challenged in your law.
Regarding
Regarding the one
matter
complaint
is
was made by
listed today
the
for-
writ petitioner to the Bureau of Zoning Offense, your lordship, Reference number 3 has forwarded without communicating the complainant to Reference number 4, who is the Director of Higher Education, your lordship, who is not an investigating agency, your lordship.
It's a Bhuya, you are appearing here,
I'm appealing for 1 and 4.
1 and 4.
Yes,
So the
what is
matter
the
is
custodian?
listed today for hearing on the point of maintainability.
And also 4 is the custodian, because the Reference number 3 has already forwarded the original copy of the complaint to Reference number 4. So the custodian of the original, that was being notarized and also duly submitted before the Reference number 3. And the case 14 reflects everything. Case 14. They may bring that original copy of the complaint also and it peruse that whether that will be investigated by the investigating agency or the department.
The Bhuya for respondent number 4,
1 and 4 Lordship.
1 and 4.
I'm sorry, Lordship. 1 and 4.
So David is available today.
Lordship.
You see this matter is listed today for hearing on the point of maintainability of the petition.
Whatever we select.
Theory is not available, Lordship.
Pardon?
So
Theory.
theory is not available, Lordship.
Oh, earlier Delhi was appeared.
Presence is required. Lordship. It may mean this 1 and 4, nothing.
Sometimes, Lordship.
If lordship is possible, next week at any day, you know. Next week, any day.
Next week.
Next Friday, of course.
Or Mr. R.P. Hazarika, Barnett of the Court of it. Bhuya for
1 and
respondent
4
number
Lordship. 1 and
Sorry.
so Lordship, sorry, Lordship, 4 only 4. Sorry.
4 and Pupone.
Oh, my God. Sorry.
It's S2 for respondent number 1. It works on its that this matter was earlier looked after by Mr. David. He accepted to it. And therefore, rest of the matter after the week there of this next Friday.
If possible, next Friday. Yeah.
Next Friday. Next Friday.
Next Friday. Deeply obliged, doctor.
24th.
24. Obliged, doctor.
Item 4. May I please, Lord? My lord, in this case, my lord, petitioner before your lordship was suspended, my lord. Paying for my lord reinstatement of his service.
Now, whether the school is provincialized school,
Provincial school, my lord. My lord, here in this case, my lord, law is that, my lord, if within, my lord, 3 months, my lord, after suspension, this, if charge is not framed, my lord, following departmental inquiry, my lord, then he may be at least, my lord, reinstated to his service, my lord.
okay.
Lordship, can this matter be taken up after some time? Miss N. Fukan is on legs in another court, my lord.
Oh,
N. Fukan, Miss N. Fukan, Nitushni Fukan. He's on legs in another court, my lord. Can be taken up after some time, my lord. He's actually handling this matter.
after some time.
Obliged.
Item 5.
Okay.
Same prayer, actually, Mr. Dikubara is on Lake's Lordship, so matter may be taken up after something. Okay.
Item 6.
Lordship, had petitioner was initially appointed as a BSc bio teacher of a particular high school by the headmaster cum secretary of that school. Page 18 is the order, Lordship.
Yes,
Page 18, Lordship. 1-8, Lordship.
yes.
His initial appointment purely was honorary teacher and on temporary basis. Page 18, Lordship. This order dated 30th/12/2026. Subsequently, Lordship, in the year 2014, his initial appointment was modified and he was treated as a permanent teacher of that school, Lordship. Page,
The school was provincialized.
no, Lordship. School was not, but receiving government aid, Lordship, as per my instruction. Lordship.
But whether this writ petition is maintainable against a private school?
No, Lordship, it is not purely private, Lordship. Dice court are, Lordship, receiving
No.
financial aid, Lordship.
Maybe, but until and unless it is provincialized, can it be said that they are employee of the government?
No, Lordship, but they are doing, they doing, Lordship, with the domain of, Lordship, the government, Lordship. They are working with the domain of the Lordship, the concerned IS or Lordship. The school is functioning, Lordship, with the inspection.
May receive some funds from the government, that is a different matter, but.
No, Lordship, kindly see, no, Lordship, that is true, Lordship, kindly see the page 18, OP to Inspector of School DDC Dhuri.
It's a say, the school is not provincialized.
Yes, he was.
Whether a petition is maintainable
Not
against.
maintainable. Not maintainable, sir. There's a decision of the honorable court that if in a non-provincial school, if the petitioner was a person was appointed by many committee or by any other person, that cannot be maintainable.
Can you show any decision on this?
Lordship, like I take it up. Reopening that law.
When? Reopening.
Yes, Lordship. Now, so far as the school is concerned, whether it is provincialized or not, there is no pleading in this.
Yes.
There's no such pleading.
Then Lordship fix it up, reopening the Lordship, I
Whether it
also
is a
prepare on this one.
non-provincialized school. That pleading is not here in this.
They
That
perhaps
petition-
they know it that it is not a provincialized.
If it
school.
is a provincialized school, if he was appointed by the headmaster, then it is not mentioned.
Yeah, on the appearance made by Sir A.J. Ahmed, learned counsel for the petitioner, raises a list of matter on Wednesday, October 2022.
22nd October. Item 7.
May I please your lordship? The engaged counsel has some health issues. May kindly pass over the matter for the day, lordship.
Okay.
My lord, I'm appearing for opponent number 5 and 6. My lord. They may be directed to give a copy to me, but I have not received.
Okay. Third Miss,
S. Yasmin.
learned counsel appearing on behalf of
M. Sharma.
M. Sarma, learned counsel for the petitioner. And also our R.R. Kosik, learned standing counsel for the Dima Hassan.
My lord, additional standing counsel, Dima Hasa, Education Department.
Dima Hassan, Education Department. You,
PCA for extension two.
respondent number 2. The learned counsel library for the petitioner submits that the conducting counsel is in disposal and the price for adjournment of the matter for the day. Accordingly, the matter is adjourned for the day. Mr. Kosik submits that the petitioner may be directed to furnish a copy of the petitioner. If it is accordingly allowed, the learned counsel for the petitioner shall furnish a copy of the petitioner to Mr. Kosik during the course of the. You have the copy available?
Yes, yes, Lordship, I will serve. Much obliged.
Item 8.
May it please the lordship. Matter relates to compassionate upon my lordship. DLC recommended lordship. Page 30. Relevant page 32 lordship.
Mr. Tevri,
Yes, your lordship.
what is it? Your stand here?
Lordship, my stand is that since the matter has already been forwarded by the DLC, your lordship, and that 18924 do not exist, that has been recalled. So definitely the matter will proceed toward to the SLT, your lordship. Actually, the matter should not have come here on. Obliged, lordship.
Item 9. Back the lordship. My lord, in this case, my lord, petitioner before your lordship passed, my lord, up to BA, my lord. But since from my lord matriculation, my lord, his father's name and mother's name are, my lord, slightly, my lord, recorded wrongly, my lord. Lordship, kindly will look page 5, my lord, paragraph 4, my lord. I have stated, my lord, what is the wrong, my lord. That due to inadvertence in the following educational testimonial of petitioner, his father and mother's name have been wrongly recorded as Saidul Haq instead of Saidul Islam. And my lord, Ummi Ani Begum instead of Ummi Ani Begum, my lord. Here, my lord, it is instead of, my lord, Islam, it is recorded Haq, my lord. Here, my lord, Ummi Hani is, my lord, clubbed together. Actually, it is separate word, my lord. Ummi Hani Begum. In this regard, my lord, there are, my lord, following the recent judgment of the Honorable Supreme Court, my lord, our Honorable High Court also passed one judgment. My learned friend was also there, my lord. I was also there, my lord. So, my lord, this judgment, my lord, whether it is covered, my lord, my learned friend may verify, my lord.
My lord, this case is not maintainable against us because petitioner seeking mandamus under Article 226. When petitioner seeking mandamus under Article 226, there must be demand. He did not approach till today to the board. How we can, my lord, act upon this? How we can correct us? Nothing else, my lord. Only paragraph 7, he only stated he approached in different officials. Accordingly, petitioner has been approaching the office of the present respondents, paying for correction when or what that, nothing else. So this petitioner is not maintainable against us. He did not demand anything. He did not approach the board for correction of it. It is covered or not, it is second time. First time he cannot claim as a mandamus. The thick mandamus.
Then, my lord, I may be petitioner, his, my lord, his contention is that, my lord, even they are not ready to accept his application because they have to pass speaking order, my lord.
What is the answer?
I asked him, my lord, and he is struggling, my lord, since matriculation, my lord, 2016, my lord, 18, my lord. So, my lord, even if my lord friend says so, my lord, which liberty may be given to him, my lord, to submit representation, my lord, before the concern.
There is a procedures, my lord, online application, and this is within time. Time limit is also there.
I, my lord, therefore, this judgment is given, my lord, on the gist of the judgment of the Honorable Supreme Court is that, my lord, if he is any other, my lord, government record, his name is correctly recorded, my lord, then there may not be any problem to correct testimonials.
Mr. Sutia, can we do this way? We dispose of this petition, granting him liberty to approach the board by filing an appropriate application.
That can be just.
And in the event of filing such an application, the board shall consider the same in
Yes.
accordance with the law.
He can approach it, my lord.
Yes.
That will be accepted by the board or not, it is up to the board.
It
my
is a
lord.
different method.
Yes, they will pass order.
Oh, yes.
The correction of the I cannot say lordship or not merit. All the judge, my lord,
No,
lordship.
yes, only you will
Yes.
file one representation.
Yes, we have had it.
Yes. Pardon me, sir, A. Formoya, Lord and Council Court of it. Lord and Sunday Council for the respondent umpire. You work for respondent number 120.
1, 2, and 3, my lord.
Respondent number 120. The petitioner is active. For wrongly recording of the name of his father and mother in his educational testimonial, namely registration card, admit card, mark sheet, and certificate pertaining to Assam High Madrasa Examination 2016, higher secondary examination 2018, and BA examination 2021. BA examination was not conducted by the respondent number 120.
My lord. My lord, respondent number 3, my lord, controller of examination, my lord, what?
Guwahati University.
My lord.
Then Mr. Sutia for respondent number 181.
He also, my lord.
What is?
No. 183 is Guwahati University.
My lord.
Yes, yes, my lord. We are only for 1 and 2.
182. During the course of hearing, Mr. Sutia, learned counsel for the standing counsel for the respondent number 1 and 2 submits that this petition is not maintainable in as much as the petitioner has not approved the board and no such document has been enclosed with this petition. And this is this, Mr. Bhuya, learned counsel for the petitioner submits that the petitioner may be this petition may be disposed of granting liberty to the petitioner to approach the board by filing appropriate representation for correction of the name of his father and mother in his educational testimonial, namely registration card, admit card, and mark sheet and card pertaining to Assam High Madrasa Examination 2016. And this rate petition may be closed. Accordingly, taking note of the submission of Mr. Formoya, learned counsel for the petitioner, and also Mr. Sophia, learned standing counsel for the respondent number 1 and 2. This writ petition stands disposed of by granting liberty to the petitioner to approach the respondent number 1 and 2 by filing appropriate representation along with the document. And in the event of filing such an application, the respondent number 1 and 2 shall consider the same in accordance with law. Terms of this petition stands closed.
My lord, he may be also allowed to one representation to the respondent number 3 also, my.
Nobody is
Liberty is also granted to the petitioner to approach the respondent number 3 by filing appropriate.
Item 37. Keep the line. Okay.
May it please your lordship. Lordship, in this case, petitioner is serving as head teacher of a LP school, my lord. Page 38, by this impugned order, my lord. Here we have made two impugned orders. We have challenged two impugned orders. First one is, my lord, page 34. By this impugned order, the search of my headmaster post has been taken away, and one respondent number, private respondent number 6, who is the CRCC of the cluster research coordinator, he was given the search from me. Then, my lord, that is 16/9/2025. Then, my lord, page 38 is the second impugned order. Although my search have been, post of headmaster has been taken away, again, my lord, by this page 38, I have been placed under suspension by the respondent number 3, District Elementary Education Officer. My lord, my case is that he has no authority to place me under suspension. He is not the competent authority. The rule does not provide him power, authority to suspend me. And he is not my appointing authority.
District Elementary Education Officer has placed you under suspension.
Place me under suspension. That is without authority. He is
Without
not the
authority.
competent authority. He has no power under the rule.
Who has the power?
Now, now director, my lord. Without approval, my lord, he has suspended me. That is not permissible. Now, my lord, why I have been suspended? That is, my lord, page 38. Page 38, my lord. May I read order? As per the report of BEO Mankasor Sor Shishumara LP School, under Sor Shishumara under so-and-so Mankasor Education Block was eroded, and accordingly, in the interest of students of Sor Shishumara, an order has been issued to shift the school to a nearby place, by order dated so-and-so, 3/7/25. By this order, my lord, they have recommended to shift the school due to erosion to another place. The order was communicated to Sri Sheikh so-and-so, the present petitioner, head teacher of so-and-so school, and directed to shift the school in coordination with the SMC members and concerned CRCC of the, that is respondent number 6. But the same is yet to be executed by the head till the report has been received. So, my lord, he is saying that, my lord, I was directed to shift the schools. That is not correct. Now, my lord, I am taking my lord to page 29. This is the, from which all this arisen, my lord. This is the base, my lord. Page 29. This is the order. Now, by the impugned order, the DEO saying that I was directed to shift the school. Now, my lord, page 29, the order, my lord. There is no direction issued to me to shift the school. My lord, page 29, order. Whereas shifting of Sor Shishumara so-and-so is required due to erosion shifting existing school, whereas field verification is submitted by the Block Elementary Education Officer and Cluster Resource Center Coordinator, so-and-so, following observations regarding the current status and proposed relocation of so-and-so school. Now, my lord, they have, following observation has been made. The present school, in this case, my lord, if your lordship can go through, there is no direction to me to shift the school. Now, my lord, last parameter, whereas as per report of BEO, Mankasor and concerned CRCC, it is recommended that Sor Shishumara LP School be shifted to Sor area located to the
southeast side of current location, my lord. This location will ensure better education. So, my lord, in view of above fact, approval is accorded for shifting of so-and-so school to a shore area located to the southeast side of Kar. Where is the direction? I was never been directed. Even this order has never been furnished to me. So, my lord, on the prima facie face, my lord, the order is incorrect. Because, my lord, again, I mind checking, my lord, to page 38. Subsequently, my lord, third para, second para, my lord, the order was communicated to so-and-so, head teacher of so-and-so school and directed to shift the school in accordance with the SMC members. So again, my lord, there is no direction in this order. Even there is no copy to me, my lord. Only copy to page 29, my lord. If my lord kindly see, page 29. Copy to PADC, the BEO Mankasar. Even no copy was given to me. No direction was there to me to shift the school. My lord, so my lord, I have challenged this on 3-4 grounds, my lord. First ground, my lord. Now, my lord, I am coming to the rule, the Assam Services Discipline and Appeal Rules. Rule 6. My lord, having. Lord, in my book, Rule 6, page 5. The Assam Services Discipline and Appeal Rules, 1964.
Rule?
Rule 6, my lord. My lord, got it?
Yes.
Suspension. The appointing authority or any authority to which it is subordinate or any other authority empowered by the government, governor, in that we have may place a government servant under suspension. Now, suspension when can be affected, my lord? The ground, my lord. Now, A, where a disciplinary proceeding against him is in contemplated or is pending. B, my lord, where in opinion of the authority aforesaid he has engaged himself in activities prejudicial to the interest or the security of the state. C, my lord, where a case against him in respect of any criminal offence is under investigation, inquiry or trial. My lord, on these 3 grounds, a government servant may be suspended. But, my lord, the impugned order, page 38, which says, my lord, there is no disciplinary proceeding against me, contemplating against me, no criminal case is under inquiry investigation. Even I am not involved in any activities which is prejudicial to the state, my lord. So, my lord, he has no power.
Lordship, in this matter, would like to get my instructions, my lord, because of the fact that as per page 38, there was the approval from the DE was pending. So I would like to get whether the approval was taken or not. Instructions have to be taken.
No, my lord.
Otherwise, my lord, if your lordship sees the other listing also which he has relied on, which is page 28, there also, my lord, shifting of the school has been given, clearly given, whereas shifting of the Kishumara LP school is required due to erosion. So erosion, my lord, there is a urgent need because of erosion, man. Something happens, there can be vast consequences, and my lord, the state will be held liable.
So like whether this copy
So
of this order was marked to the petitioner.
My lord, that I have to get the instruction. So that therefore, my lord, will fix it, my lord, maybe in the after say, my lord, this is from South Salmara. After 10 days, or my lord, maybe a week, my lord, I'll get my instructions, my lord, till then. Because that will be crucial, well, whether he got it or not, I'll get the instructions.
My lord,
Otherwise, my lord, the page 28 he's relying on, it's clearly it is showing also that it's regarding 29, shifting of charge issued Mara LP school is required due to erosion affecting this existing school.
If that is the
Thus it is given here, madam.
suspension, you would to have
He's saying that he's not got a copy of this particular letter order.
Yes.
That has to be seen, we have to get the instructions, because today it's come for the first time. So let me get the instructions, my lord.
Heard Mr. AMR.
My lord, may I submit one thing. Even copy is received, my lord, therefore, my lord, page 38, therefore pending approval of the director elementary Assam. During pending approval, he cannot suspend me without impugned order reflects, my lord, during pending approval. How it is, my lord?
The copy is already given.
Approval is, that means approval is not taken. So it is unauthorized, my lord.
Lordship
If
sees
my
the bottom
prima
part of
facie
the,
case,
bottom part of the, thing, my lord,
Lord,
copy has
rule
been
does
given to
not
the
permit it,
director.
my lord. My lord,
Lordship sees the bottom part, the director, copy has been given to the director.
why approval is there any approval? My lord, prima facie case.
Therefore, I'm asking, my lord, that some time may be given because I'll get my full instruction, I'll complete my instruction. Therefore,
My lord, my case.
Protocol learned counsel for the petitioner and Mr. A. Kokon for the
okay, so respond 1 to 5.
department. This petition under Article is subject to the petitioner has given the order dated 29/5 issued by the district elementary education officer South Salmara Manchester. It is to be noted by the order dated the petitioner was placed under suspension with immediate effect. Mr. Prabhakar learned counsel for the petitioner said the district elementary education officer is not the appointing authority of the petitioner, and without taking any approval from the director of elementary education, we have placed the petitioner under suspension, and the grounds mentioned in the order for suspension is not in terms of the Rule 6 of the Assam Services Discipline and Appeal Rule 1960. 1964. And further, Mr. Matukar has pointed out that the order dated 3/7/2025 by which the school in which the petitioner was serving was ordered to be shifted from the existing class to another class on account of erosion. But the said copy of the order, but the copy of the said order was not furnished to the petitioner, and therefore he was not aware of about shifting of the school from the existing class to another class. And as such, Mr. Kondokar submits that the impugned suspension order dated 28/9/2025 is arbitrary and illegal and likely interfered. Mr. A. Pukon learned standing counsel for the respondent authority submits that he may be granted some time to obtain instruction as to whether the district elementary education officer Salmara Manchester Satnimari has obtained approval from the director of elementary education for placing the petitioner under suspension and as to whether the order dated 30/7/2025 was furnished to the petitioner or not. Accordingly, it is provided that justice shall place the matter on
7th November, 3rd November, 3rd November. My lord, till then, my lord, matter, till then, my lord, the matter may be this.
Let the
get the thing.
town will consider.
Then,
Declare
my lord,
there the petitioner will be-
then in the last part of the month, my lord, then in the last part of the month, my lord, because suspension, I was suspended without
Let
authority.
it be on 3rd of October. Oh, no, sorry, November.
I don't,
I'll get my instruction.
I'm. Jump 38.
My lord petitioner, before your lordship, initially she was appointed as an assistant teacher and subsequently she was transferred to the HN Seminary HS School, Bokribari, in the year 2011. By order dated 30/1/2023, page 31. In the interest of public service and until a further order, I was allowed to hold the charge of principal of the school. This order was issued by the director for appointing a principal, either in charge or regular. Director is the appointing authority. And thereafter, my lord, I have been serving as the principal of the school. Suddenly, my lord, page 33, some of the guardian, page 33, vernacular is page 35, submitted some complaint against me, stating that I have charged exorbitant fees, admission fees from the student, and the food quality of the hostel, girls' hostel, is also not sufficient. And therefore, my lord, I was asked to submit my reply, page 36, that show cause has been issued by the inspector of school to me. Then page 38 and vernacular is page 41. I have submitted detailed reply denying all charges because I never charged 900 rupees. As per departmental notice, I have charged only 400. And there is a hostel committee. I cannot improve or decrease the food quality of the hostel, my lord. And regarding the fees taken from the elementary school, I have categorically denied that since elementary education is free in the state of Assam throughout the country. So there is no question of taking any fees from the student of elementary school. And thereafter, my lord, this is the base 50 is the food quality, the item of foods that has to be supplied by the hostel management committee. Then, my lord, one inquiry has been conducted. And thereafter, I was not aware what happened. I was not asked to submit my reply before the inquiry committee. There was no disciplinary committee conducted against me, merely on the basis of such allegation, complaint, though I have denied all the charges. Then page 64. This is the impugned order, first impugned order. In the interest of public service and based on adverse teacher and guardian complaints, as per inquiry report submitted by the inquiry officer so-and-so, further to the approval of Honorable Deputy District Commissioner and Thuburi and Srimati Abida Yasmin in charge of the hereby attached to Bahir Salmara Jonata HS School in the position of assistant teacher till final recommendation of the disciplinary action. That means, my lord, no disciplinary action has been undertaken against me, and that order has been issued by an authority who has no jurisdiction, my lord, inspector of school. I have been serving as a principal. I have been demoted to the post of assistant teacher. That amounts to violation of my natural justice because no inquiry report has been submitted to me till date, and I was not given any opportunity. No departmental committee has been constituted as per Rule 1964. There is no proper inquiry. And page 65, I have been directed to join in the new place of posting by 10/10/2025. Though the inspector of school has no authority. Then I have submitted a prayer petition for granting me unleave for 1 month on the ground of medical ground, my lord. Page 69 is my medical certificate issued by the authority. And the inspector of school, only he has sent a WhatsApp message stating that your leave is rejected. In this connection, I would like to refer you lordship recent judgment that stating that merely submission of allegation is not enough. That has to be proved in a duly constituted departmental proceeding. Unless in the departmental proceeding, I was not given the opportunity of hearing, an inquiry report is not submitted to me, the impugned transfer order, which is amount to punishment by demoting me from the post of principal to the assistant teacher, that too far away from the present school, my lord. That amounts to violation, my lord. And therefore, my humble prayer would be that till the next returnable date, I may be protected, my lord. This is your lordship judgment, my lord. That issue was two different parts, my lord, seniority issue as well as. This 38. Item. Yes. This amount, paragraph 12 and 13. The departmental council also issued same allegation that due to some allegation, complaint leveled against me by the guardian or the student, I was given punishment transfer. Page 12 and 13. Paragraph 12, a contention is being made by the respondent number 5, private respondent.
Okay. Yes, sir. Verma?
Yes, madam. Madam, there is a complaint against the teacher, madam. And moreover, madam, against them, madam, so-called notice was issued. And thereafter, some documents was asked to the in-charge teacher, but she was failed.
No.
And there was a reminder also issued on Annex 12, page 55. So here it is stated, with reference to the subject cited above and the letter under reference to were directed to furnish the registered documents as mentioned in the previous letter within 3 days of the writing of the same. And this is to remind you to furnish the requisite documents as sought for. Pertaining to the ongoing inquiry by 13/8/2025 without fail. The documents earlier sought for are yet to be received by the office of the undersigned. Should you fail to furnish the requisite documents within 13/8/2025, it shall be a deliberate non-compliance with the directive of the inquiry officer, and such conduct shall be constituted as an act of insubordination in the performance of your duty. And thereafter, my lord, the issued a letter regarding the reminder seeking registers and documents and with regards to the inquiry there. With reference to the subject and letter number so and so cited the above, I have the honor to state you that the required register and documents are submitted at the director of Fund Local Audit. So it has needed 20 days to submit the same, or I will submit the documents within 20 days. After receiving that man of the 1/9/2025.
Page 58.
Page 63.
Page 63.
It has already crossed my lord 13/8/2025. Page 61. Type copy is the relevant portion. That 1/9/2025. Submission of documents as sought inquiry thereof.
My lord, I clarify, my lord, the inspector has directed me to submit some documents because at that time annual audit was going on by the local audit, and therefore I sought for some time that after receiving the documents from the local audit, I will submit all the documents, and accordingly I approached the authority, my lord. Page 58. As per your letters, I have submitted the following documents. Kindly accept and consider my prayer. Until that, my lord, I have not joined in the new place of posting, so balance of conveyance is still in my favor, my lord. Till the next return will that, my lord.
So where it is of all?
My lord,
Pahir Salmara Donata Research School is situated.
my lord, at least 25 kilometers from the present school, my lord, from my residence. And that is the not issue, my lord. Since I am serving as a principal, I have been demoted to the post of assistant teacher. That too not by a competent authority, director. That is the.
Verma, whether the inspector of the school has the authority to transfer her and also to demote her from the post of vice principal to assistant teacher?
Principal to assistant teacher. That too till final exam recommendation by the director as per the impugned order. Till that, no recommendation has.
You were the in-charge headmaster.
Principal.
Principal.
Yes.
My lord, annexure 16, my lord.
Page 65.
64, 65 similar, only date has been, last date has been given to join.
In continuation to the previous order issued from the office of undersigned by this order so and so dated 24/9/2025, and whereas in the interest of public service based on adverse teachers and guardian complaints, and as per the inquiry report submitted by the inquiry officers, Srimoti so and so, Commissioner and Executive Magistrate Bilasi Para, further to the approval of the Honorable District Commissioner, so and so in charge principal of Asian Seminar HS School is hereby attached to Bahir Salmara Janata SS School in the position of assistant teacher till final recommendation of disciplinary action as deemed fit by the Director of Secondary Education on the basis of an inquiry report which is communicated to the Director of Secondary Education Assam by the letter dated 1/9/2025.
Last
So
time.
it is now under the consideration of the Director of Secondary.
Then last sentence, my lord.
And further, Srimoti Evita Asmin, in charge principal of Asian Seminary School, is directed to join her new place of posting on or before 10/10/2025 without fail. She would cease to serve her duty in the capacity of as in charge principal of Asian Seminary HS School until a further order. So my lord, there may be apprehension of manipulation of records or anything else. So my lord, at least some instruction or notice may be issued at this time, my lord.
No, in that transfer order where it is stated that this departmental action is conducted with. Is it mentioned?
But there may be some apprehension, my lord.
And it appears that the transfer order is passed in lieu of punishment.
And against her, my lord, some allegation is that there from her colleague teacher also,
You
and
tell me
guardian also
whether-
there.
Whether the copy of inquiry report was furnished to her,
No,
whether she has been given an opportunity of being heard.
no.
Regarding that, I have to take instruction, my lord.
Okay, you obtain instruct. We'll grant you time. But in the meantime, we will stay the order.
Yes.
Third, Ms. I am Sharma, learned counsel for the. That means I use Sharma, learned Islamic counsel for the respondent in secondary education department. Mr. Sharma, learned counsel for the petitioner submits that the petitioner was serving. The petitioner has been serving as the in-charge principal of HN Seminary HS School, Bogribari. Pursuant to an order issued by the Director of Secondary Education dated 30/1/2023. Mr. Sharma further submits that thereafter on 26/5/2025, some of the guardians of the student filed one written complaint against the petitioner alleging some malpractices with respect to collection of admission fees, admission form fees, and inflated admission fees, and supply of service rendered food in the school hostel. And the same were absolutely false and faithless. And on the same day, the inspector of school, Dhuguri District Circle, Dhuguri, issued one focus notice to the petitioner to furnish a reply. The petitioner has submitted her reply on 28/5/2025 denying the allegation. But till date, the petitioner has not received any inquiry report pertaining to the allegation. And thereafter, based on the inquiry report, the inspector of the school, by order dated 24/9/2025, removed the petitioner from the post of in-charge principal and attached her in another school, namely Bahir Salmara Donota SS School by demoting her to the post of assistant teacher and ordered her cease to serve duty in the capacity as in-charge principal of the school. And thereafter, by another order dated 7/10/2025, he was directed to join the new school within 10/10/2025. So Sharma further submits that the inspector of the school has no authority to demote the petitioner from the post of in-charge principal to the post of assistant teacher and also to transfer her from the present school to a school which is situated at a distance of 25 kilometers from the present school. And that without giving an opportunity of being heard, the petitioner was transferred from the present school. And the transfer order assumed the character of a punishment, and as such, the same is liable to be interfered with. Mr. U. Sharma, learned counsel for the respondent authority submits that he may be granted some time to obtain up to that extent. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that notice be issued to the respondent returnable in 4 weeks. Step be taken by research with ATN also by usual process upon respondent number 4, 5, and 6.
4 and 5 is my lord, government, my lord.
Okay.
6 is private respondent in,
Or
he-
respondent number 6 by research with
he has been
ATN
given the
by
academic
usual
search.
process within a week from today. However, no formal notice is required to be issued to the respondent number 1, 4, and 5 since Mr. Hugh Sharma and Ms. S. Kaur entered appearance and chief notice. However, expert requested copy of the petition to be furnished to them during the course of the day. And further, taking note of the submission of learned counsel for both the parties. And also considering the fact that the impugned transfer order was passed without according an opportunity of being heard to the petitioner on the ground of some allegation, which is contrary to the principle laid down by Honorable Supreme Court in the case of Sumesh Tiwari and Union of India and others, reported in 2009 to SCC 592. This court finds a prima facie case made out for staying the impugned orders dated 24/9/2025 and 7/10/2025. And the balance of convenience and the irreparable loss is also found in favor of the petitioner who has not yet handed over the search. And accordingly, the impugned orders dated to substance state still returnable. Place the matter after 4 weeks.
High law, please.
Item number 2.
May I please your lordship? Lordship, here, my lord, Director Elementary Education already communicated to see CEO Bodhara matter. So seeking some instructions, so sometime, yes.
So, Madam, you say the petitioner was appointed. The service of the petitioner was provincialized with effect from 5/2/2021.
Right.
Since then, he has not been receiving his salary. So you haven't granted 1 month time. You failed to obtain any instruction.
No, my lord, Director Elementary Education already communicated to see district.
Pardon?
Kind of. For the necessary instruction. So sometime, until allowed. We need some time. We have not received any information. from that. After 10 days.
Third miss,
E Devi.
third and council for the petition. And open third and council for the implemented part. That. You know, they granted further 10 days time to obtain necessary inspection. However, it is provided that recessal is the matter on 24th of October. And in the meantime, this coupon shall obtain the inspection and apprise this court on next day. 24th.
Timing item 4. Map is the receipt. My lord, this case, my lord, I have verified the record, my lord. I have filed one, my lord, additional affidavit in this matter, my lord. But it is not tagged with the matter, my lord. Kindly, I may be allowed to bring this affidavit, my lord, and matter may be taken up at 2 p.m., my lord.
Have some difficulties, any other day.
After some time, my lord, before 2 p.m. After some time. Yeah, my lord.
Okay, after some time.
Timing item 5.
May I please, Your Lordship? Lordship, in pursuant of the admission notice, my lord, I registered myself for admission in the MBBS course, my lord. Thereafter, my lord, I was selected in the provisional list for admission, my lord. Annexure, my lord, 20, page 26, my lord. Relevant portion is, my lord, page 27, my lord. This is the provisional select list, my lord. And
number?
I was selected
Page number?
along page number 27, my lord.
7.
27, my lord. Serial number, my lord, SR 2978, my lord. Shahinur Islam, my lord. I was selected along with 4 others candidate, my lord. Page 26, my lord.
Yes, Mr. Bora.
Thereafter, my lord, I was called for counseling, my lord. After counseling, my lord, the impugned order was issued on page 28, my lord. All the candidates, my lord, including me, my lord, was cancelled, my lord, without any individual reason, my lord. Page 28, my lord. Impugned order is, my lord. This is violation of section
So
30.
after this examination by the medical board
Yes, my lord.
on 25/9/2025, the selection has been cancelled.
Yes, my lord.
So
By the
Bora?
medical board without any individual reason, my lord. They cancelled all the candidature, my lord, under PWD category, my lord. They cannot done, my lord. This is the violation of section 32 of the Act, Rights of Person with Disabilities Act 2016, my lord.
Yes, Gaurav.
My lord, I have not been served with a copy of the restriction letter. I don't have any. Because they have not served a copy of the restriction to.
Why?
Lordship, I will verify, my lord, the otherwise.
Heard me, sir?
HL my lord. Lordship,
HL for
last
learned
date,
report of petitioner. Then
Lordship, last date for admission is 22, my lord. 22/10, my lord.
No, no.
So there is urgency,
It
my
has
lord.
been extended, my lord. Even counseling is up to 27th, my lord. Now it has been extended.
okay. Then
Till
also
till
heard
then, my lord,
petitioner heard
one post may be
for
reserved,
the
my lord.
offer. Yeah.
Till then, my lord, one post may be reserved, my lord, under.
You have failed to furnish a copy of the petition to the council for the health department.
Yes, my lord.
And this is the second time the case has been listed before the court.
I have furnished already, my lord, furnished, my lord.
Mr. Bora, learned standing counsel for the respondent authority submits that he has not been furnished with a copy of the petition. Accordingly, it is provided that learned counsel for the petitioner shall furnish a copy of the petition to Mr. Bora during the course of the day. This is a list the matter on 22nd.
I have already furnished, my lord. Most of them.
God bless you, my lord.
Then, the petitioner was elected and appointed long back. That is 2011-1999. Then he joined in Sesame School Miller, Harvard there. Then his salary was not paid.
Mr. Bora, Mr. Sarma, you have filed your additional affidavit.
Lord, we have filed our affidavit, additional affidavit, bringing on record that original select is the actual select list.
Hmm.
And in that relevant point of time, that original select list was also produced before Lordship. Now
No, no, no.
subsequently,
That
the
is-
Lordship has again directed to produce it. So I have brought the records, that original select list, where the name of the petitioner is not there. The name of the petitioner is not there. That select list I have brought today. The original select list. May I place it before your Lordship?
And before that, Lord, may I submit?
In this select list also, the name of the petitioner is not there.
But I have a list, Lord, on which my name is there. And there is a date, Lord. Date is 27/10/99. That is the select list date.
That I have clarified in my earlier affidavit, Lordship.
Why?
So this is the actual select
Mr.
list of
Sarma,
20.
this is also not the original list. It is stated that verified with the original list.
Oh, my Lord, that is my submission.
This is the only
No,
record.
no, no,
we
that
have
cannot
with the
be.
department.
And as per Evidence Act,
I am
Lord,
told-
that cannot be accepted.
I am told by the director that this is the record they are having in original with all the due signatures signed by all the department heads, the concerned officer.
And the list you lost before lordship, probably with the copy, same copy with me, my lord, and that is not the original list, and if it is not original list, my lord, that cannot be accepted, my lord. And as per Evidence Act, my lord, under section, that is 60, earlier it was 61, now it changed, my lord. 59. Now, new Evidence Act, my lord, under section 59, it is not accepted. That is secondary evidence. Secondary evidence is not accepted. And first of all, may I kindly see my petition, Milord, where I have annexed two Milord select list. And that is Milord dated, one is dated 27/10/99, annexer Milord 5, page 24. Where my name is appeared, Milord, is appeared. And serial number?
Annexer?
Annexer Milord 5, page 24. And 24 will have only this portion type copy and another next Milord page 25 Milord, that is the original photostat copy supplied by them in RTI. Page 35, page serial number 35, my name is there. Milord. Page 24. Why not? Has your lordship got it?
It's a photocopy, Mr.
Yes, this is the copy supplied by them. I am not denying, saying that it is original copy. It is a photostat copy.
This particular averment has been countered by in our earlier affidavit. Lordship, may kindly take up my.
No,
affidavit filed by
affidavit is
the
other thing.
director.
Record is other. When the record is produced, we will lordship, and record it says that it is photostat copy. So the oral evidence or oral saying only that this is Milord, the statement in the affidavit, that has no bill.
Page number 56.
No,
Lordship.
here some original signatures are there.
Original signatures are there. This is the one which is verified by the concerned officer.
No, I have also given.
And Lordship, the one which the select list which was placed before annexed with the writ petition, I have clarified in my affidavit. Lordship, may kindly peruse the affidavit, page number 56. The earlier affidavit filed by the director. Page number 56.
Yes.
Paragraph number 5, Lordship. The first paragraph number 5.
65.
56. Paragraph number 5. That, have a Lordship. That the deponent states that as reported by the district elementary education officer Karimganj by letter dated 1/6/2023, the advertisement was issued but the petitioner was not selected. As per Honorable Court's order dated 15/12/2013 passed in WPC number 1103 of 2011, the case of the petitioner was placed before the expert committee for consideration of her claim for payment of salary. Thereafter, the government verified the records and after verification issued an order on 18/7/2013 stating that the name of the petitioner did not appear in the proper select list dated 27/10/1999, which was approved by the sub-divisional level advisory board Karimganj, which I have placed before your lordship now. The select list which has been obtained by the petitioner is not a valid select list. The petitioner submitted a review petition dated 13/8/2013, which was rejected by the government via order dated 26/9/2013. Paragraph number 6, the DO Karimganj has further reported that the petitioner obtained the select list from one Samuel Datta, who is not the official authority. In paragraph 19 of the writ petition, the petitioner also states that she obtained the select list dated 27/10/1999 for 111 numbers of candidates through RTI from Sri Samuel Datta. It is to be mentioned that the directorate has issued a direction to the deputy director of schools Karimganj to file the FIR and criminal case on the charge of fraud and forgery against the Samuel Datta petitioner in WPC number. So therefore, the select list which has been obtained by the petitioner is from one Samuel Datta, who is not the appropriate authority. against which there is a direction to file an FIR by the director. Now, number 7, Lordship, that the name of the petitioner figures in the list dated 13/11/1999, which has no valid original document. So the appointment of the petitioner was found illegal, as the petitioner's name is not enlisted in the valid select list as per government order dated 18/7/2013. The petitioner is not entitled to arrears salary as claimed. The Honorable Court, by the order dated 12/3/2020, passed in WPC number 5094 of 2013, directed the authority to re-examine the claim of the petitioner in the light of the select list produced by the petitioners, and to make another verification as to whether the name of the petitioner finds place in the select list dated 27/10/1999. The Honorable Court further directed that if the name of the petitioner is found to be included in the said select list, the petitioner would be entitled to be declared as validly appointed teacher, and she shall be entitled to all the consequential benefits, including arrear and current salary. However, Lordship, now this is important. However, on verification, it is found that the name of the petitioner did not figure in the valid select list dated so and so, so and so, and therefore the petitioner is not entitled for any benefit. A speaking order is required to be passed, however, this so and so, so and so. Therefore, that verification has also been conducted subsequently in terms of this Honorable Court's order, passed in WPC number, Lordship, 5094 of 2013, dated 12/3/2020. Therefore, now subsequently your Lordship has directed me to produce the original select list, which I have brought on record by our subsequent.
Kindly see where from my land is to me, Lord. Paragraph 8, my Lord. Paragraph 8, page 58.
No, I
I'm
have
coming,
read
yes,
paragraph
your I'm reading. That the deponent said that the petitioner was categorized as illegal teacher. On that basis, I filed an RTA application before the authority, and the authority supplied me a copy of by which I have brought on record, filing affidavit. And that is for before Lordship, that there are a huge number of teachers who were as a illegal or irregular, but my name is not there, my lord. I have the copies there, my lord, and I have soft copy to him also.
Yes,
my
Lordship.
friend.
Yes, Lordship.
But my name is not there. If they are saying my appointment is irregular or illegal, then my should never have placed in this affidavit, in this list, my lord.
Lordship, to that extent, yes, Lordship, my learned friend has furnished me a copy of that additional affidavit. Now, Lordship may kindly peruse that page number 90. The
Yes.
heading only speaks for everything. Heading, Lordship. Page number 90, the list which has been provided, furnished, annexed by my learned friend. Particulars of working persons who were appointed illegally, irregularly during the period from 1991 to 2001 in different upper primary and lower primary schools. So working teachers.
I'm working
This-
until then, at the time I was
This is
working, and
the
I was
claim of-
I was
he is
appointed
working.
99. So within this
It is
period.
not that the list of illegal and irregular teachers. Now, in terms of the cabinet decision, the Lordship in 2012 itself, the advertisement was issued for all the irregular and illegal teachers across the state. So all the petitioners, those who did not receive their salary, they appeared before the screening committee. Screening committee was constituted. Now, if the learner friend's client did not receive his salary, he should have appeared before the screening committee in terms of the advertisement. But because on several occasions, advertisement was issued to appear before the screening committee. They did not appear. Now, this list is a particular list who were working, particulars of working persons who were appointed illegally and irregularly teachers. This was a working teacher. The status.
I am working since 99. I am working.
Petitioner, but according to this, he might not have been working. That is
And
why he
during
was-
service, I was transferred there also, my lord. I have given an excerpt.
Yes. And that advertisement was also issued in terms of this Honorable Court's order in several.
No, I have not,
Petitions, basis of writ petitions.
I have not, I am not aware.
That exercise was conducted in terms of this Honorable Court order, the screening committee was constituted, and all these issues were verified. Illegal, irregular teachers across the state. In that particular screening committee, the petition did not appear.
No, I was not aware of that.
Now, the list which has been produced by him is
And
Mr. Rosid,
Well.
you please go through the original file he has produced to the court today. If you check it whether your name is there or not.
Today itself, my lord.
Today,
Lord,
Fine.
we'll take it out after some time or at 2 p.m.
Lord,
At
The
2 p.m.
meeting, let it go through
Lord,
the file.
Lord,
But it has to be in his presence. Yeah.
Lordship.
My lord. Thank you very well. I never wait for it.
Timing item 4. May I please, your lordship? My lord, petitioner before your lordship is a senior science teacher, my lord. And he went to the school in time, my lord, but due to certain, my lord, his need for toilet, my lord, submitting, my lord, proper application to the headmistress, my lord, he went to his, my lord, nearly, my lord, located his residence, my lord, for half an hour, my lord. In the meantime, my lord, concerned BO went there, my lord, and finding him, my lord, absent, he was placed under suspension. His application, my lord, in proper, my lord, application to the headmaster is page 14, my lord. And within this, and my lord, this dilapidated condition, my lord, his toilet of the school is page 15, my lord. And even then, my lord, he was suspended on, my lord, page 16, annexure 3, that, my lord, he was found absent in the school. It was suspension order was passed on 17/8/2024. He immediately submitted one representation by page 17, which was not being considered. He approached this honorable court, and this honorable court also passed one positive order directing to consider and dispose of his appeal against the, my lord, suspension, but it was not considered. In the meantime, my lord, DP, my lord, the charge and charge sheet was submitted, my lord, following the inquiry, but it is long after 3 months, my lord, which I have submitted before this honorable court by additional affidavit, my lord. Page 43, my lord, it was submitted only on 22/1/2025, my lord.
Page 43.
Page 43, my lord, in the additional affidavit. Annexure B, my lord, page 43, it is statements of allegation was submitted only on 22/1/2025. Yes, my lord, it is long back. Therefore, my lord, I have annexed one judgment passed by your lordship,
Mr. Pormaya,
my lord.
whether this suspension order was reviewed by the authority after 3 months?
No, my lord, never reviewed, my lord.
Within 90 days?
Yes, my lord. Never reviewed, my lord.
Never reviewed.
Never reviewed.
Yes, madam.
And it may be, and I will take instruction. And can you see the suspension order? Page 16. Here, my lord, stated that, can you see, the DO also has stated that this is a regular practice. The teacher is involved with them. So, my lord, kindly some time is allowed. Excel revision.
No, we are not concerned with the actual result. We are concerned with whether after, no, within the period of 90 days, this suspension order was reviewed or not by the authority.
This instruction not available in email today.
Obtain verbal instruction at 2 p.m. today.
2 p.m. I have some difficulty already. I have stated. So my
Okay, before
friend,
1 p.m. then.
Yes.
Before 1 p.m.
Oblige much.
Whether any order was passed, extending the suspension period.
Diploma. Item number 11, parted matter.
Lordship, in this matter, Lordship, my learned colleague, Mr. N.J. Kapronia, here, nothing is handling. And today he has some difficulty, Lordship. And he,
No, I have seen him
no,
here.
he's here, he was here. And, just now he has put, here,
Let him come.
let him.
Let-
Yes,
After some time,
he's not prepared.
Mr.
and
Kalunia come.
Item number 60.
My lord, it is a matter which is pending.
Receipt, inspection lordship, 1 week time.
My lord, here, my lord, more than 1.5 years
Just 2 lordship.
already been passed, my lord. They are not
24
not
matter,
filing
1
the
week time,
objection.
lordship, 1 week time granted for filing affidavit. Therefore, some time finally dispose of the matter. It's not a finally disposal. Just 1 week will file affidavit. Just reopening.
Matter is pending 1.5 years, my lord.
24 matter will dispose of matter.
All the time they are
Some
taking
date,
time.
Matter will be discussed finally. We will file definitely on reopening. That's true. Sometimes.
Okay, let it be on 24th.
My lord, that specific direction may be given, no further time
Yes,
will
yes,
be
sir.
allowed, my lord.
Okay,
No,
we'll keep the matter as parted.
yes, lordship.
Heard Mr. Desarma, Learned Counsel of the and also heard Mr. Bhuya,
Lordship.
Learned Assistant to the Higher Education Department. Mr. Bhuya, thanks for listening the matter after a week, so as to innovate to file the affidavit in court. There is allowed, let's accept the matter as parted on 24th. 24th. It is further made clear that no further sum could be given to Mr. Bhuya to file it affidavit.
Item number 17 and 18.
May it please your lordship.
Well, in this case, although affidavit has been filed by the Director of Higher Education, court is directed to file another affidavit by the secretary. But for that, I need some further time now. Affidavit to be filed by the secretary, because instruction yet to be received from the secretary office.
Your lordship, that's a 6-month-old story. I don't mind my friend taking time. But if your lordship peruse the last order, there was a direction that it will proceed. But I know your lordship, if the matter proceed, then again, there will be some complication because without the affidavit from the secretary, the matter cannot proceed, your lordship. Because there are technical things on the basis of one document, my claim was rejected, which was issued by the secretariat. So therefore, either the secretary files the affidavit in the 1 week or let him be personally present before this honorable court. Otherwise, they are not doing. This is the last 6 months old story, your lordship. Your lordship has been passing orders after orders. The director affidavit is neither here nor there. It is nowhere.
Sir, that's already several weeks have been granted to you to fight that.
Yes, sir.
It seems the secretary is not taking the court's order seriously, your lordship. So there need to be some chilling effect in the spine, your lordship now. The lordship will ask them to either personally appear on the next date or by the next date they file the affidavit, your lordship.
Heard Mr. Arjun, Learned Counsel. Then SIS, Learned Assistant of the Court, 1, yeah, 4. Then
Dr. T. Agarwal for you.
Dr. T. Agarwal for respondent number.
Lordship, there are two requisitions, the respondent number varies in the two requisitions. So maybe recorded.
In WPC number 2779.
It's the respondent number 6.
Respondent number 6 and respondent number 7. This is only help for respondent number.
Lordship, in WPC Rule 779/24, I am respondent number 5.
Finances file their affidavit.
We file our affidavit.
Okay. Yes, sir, does the learned counsel for the respondent number 1, 2, 3, and 4 submits that he may be granted 1 week time to file the affidavit in opposition
By the secretary.
by the secretary. So senior learned counsel for the petitioner submits that the affidavit in opposition of the secretary is very much necessary, as the affidavit in opposition filed by the director is neither here nor there. And under such circumstances, Mr. Das is granted 1 week time to file the affidavit in opposition of the secretary. Let's list the matter on
27th, your lordship.
November.
Your lordship will make that observation. Either they file the affidavit or the secretary will be personally present before this honorable court to justify the same.
No. On that ground, secretary cannot be.
Otherwise, they are not giving otherwise it seems that they are not giving a botheration to this
No,
court's order.
If they fail to submit the affidavit, we will impose some cost.
I'll indicate.
But the Supreme Court has issued SOP when the government official can be directed to remain present.
I understand, your lordship, but the court's orders are being taken lightly, your lordship. That has to be taken into
proceed with the materials on record also, Lordship. If the director refuses, Lordship, we can proceed on the materials available on record.
Yes, that can be.
Yes.
Let us see.
Sorry, number 19.
Lord, should we kindly pass over this matter for time being?
Numbers 20 and 21.
My lord, before starting, my lord, IA is pending since long back, my lord, in his case, my lord. 2027, my lord, for impeding as a party respondent, my lord. Since long back, it is before your lord.
IA is filed by?
Filed by me, my lord, as to impede as a party respondent in WPC 4498, my lord. 24, my lord.
How you
I am the senior most here. I am the senior most teacher, my lord. So I am, my lord, by the order of in favorable order is my lord of the repetition. I may, my lord, lost my right, my lord. That is why my apprehension, my lord. Kindly peruse page 16, my lord, in IA. Page 16, IA, Annexure A. His name placed at serial number 3, my lord. Mosraf Hussain, and my name is at serial number 1. Abu Tahir Sheikh.
My lord, here, my lord, this implementation question come later, my lord. Lordship, the affidavit filed by government, my lord, this affidavit may be perused. Then lordship, if necessary, his prayer for implementation may be considered.
No, since long by it is there, my lord. I have
Keeping long back is not matter, my lord.
May I make a small submission if they don't disturb? The matter relates to provincialization, and my friend from the petitioner side, he is asking for his provincialization. Against the post, one of the post of the language teacher. My lord, as for the precedent of this honorable court, as well as the decisions taken by the government at various level, when these honorable courts send the matter to the government for reconsideration, what they have said that if there are 2-3 language teachers were provincialized and somehow one eligible person was left out. In my friend's case, he is demanding that he is a social studies teacher, so that one of the teacher of the language will go and he will come in. That is the scenario. Now, in earlier repetition, my friend added both of us as respondents. But in this repetition, in this current repetition, which is before my lord, he did not add my friend, who is headmaster cum language teacher, as he was provincialized. But if my friend's contentions to be taken, then among the language teacher, I am the senior most. I come in. But if my lord accepts his version, then he goes.
But incidentally, he's not even a party to the writ petition.
Earlier, yes, my name is.
So it's not that I'm supporting him. When I got the IA copy from him, then only I realized that yes, he is also genuine party, ought to have been in the writ petition. Well, it is admitted that I am the language teacher, he is also language teacher, but as a language teacher, I am senior. I'll survive. But then if this person has to go, he is not a party to the petition. So that is the reason IA is filed. That's all, my lord.
That order it is typically my name was here, the earlier order. Yes, the next. Earlier order. It was yes. Mr. Decker.
My lord, now, my lord.
My lord, what I have submitted
Here all
as
the
the court
parties.
officer, I submitted, my lord.
Now, my lord, I must appreciate my learned senior friend, my lord. My case is, my lord. Kindly allow me to make my submission here, my lord. My lord, admittedly, the district level scrutiny committee initially, my name is recommended for the post of social science, my lord. There are 5 teachers, my lord, 3 language teachers, 1 mathematics science, 1 science, social science. When the SLC had at the time of provincial, my case has not been considered, then I approached before this court. And this honorable court had, after hearing, I made party of the both of them, my lord. Since, my lord, as per the 3111, my lord, social science is the mandatory compulsory post, my lord. Since among them, who is taking my post, I don't know. Therefore, we have made the party. According to this matter, regional court disposed of the matter. And thereafter, what happened, my lord? The authority, they heard all the sites, my lord, and found, my lord, cancelled the post of that. Yes, his post was cancelled, my lord, and my name is recommended for the post of social science, my lord. Then again, they are sitting silent about the matter. Then I instant writ petition file, my lord. So I deemed it that the person whose services cancelled, my lord, therefore I made him party here, my lord. The person whom considered by the authority, I have not made him party. Since his case is continued, why should I disturb him, my lord? Therefore, I am agreed, my lord, that that person, my lord, in the year of 2020, after cancellation order approached before this court, the item number 21 is concerned, my lord, and obtain one stay order, my lord. Since 2023, he's enjoying the provincial benefit. When I am social, what wrong on my part, my lord? Lordship, in this case, 2 affidavit filed by the government, my lord, and latest affidavit filed by government has recommended 5 teachers recommended at the social sense me, my lord. Then why should I suffer for their dispute, my lord? In this case, my lord, 2 judgment I have enclosed here, my learned friend, Mr. Abedin Sir, my lord. He's also one of the party in this case, my lord. I represented one teacher of social science. He represented one post of language teacher, my lord. Then Honorable Justice Mr. Yukenar, sir, my lord, what they said, the social science teacher is a specific court. There is no dispute with this social science and language teacher. In among the language teacher, only the senior's case will be considered, my lord. But here my case is very clear, my lord. For dispute of this language teacher, why should I suffer, my lord? Since 2020 on that and enjoying the benefit of provincial, now 2000 end of the 25, but due to pendency of the case.
That's all right. If the order passed by this court will affect him, then definitely we have to hear him.
My lord, my first of all, my lord, my learned friend, I may be allowed. Kindly, my lord. He is implemented, may be allowed, my lord. Otherwise, same prayer will be continue in the next final date, my lord. Let him.
What, sir, is the current counsel for the applicant? Sir, sir, take the current counsel for the
I'm petitioner.
opposite party number in the IA.
In the I am, my lord. I have one more part.
What?
But 8.
8.
No, 1, my lord, 1.
The
Petition as 1.
Musharraf Hussain.
1.
Musharraf Hussain.
Yes, my lord. 1.
1. And Mr. Abedin for respondent opposite party number.
Miss 7, my lord.
7. No. 7 is it.
He's, my lord, my learned friend is 2, my lord, 7, and he is 8.
2 to 7. And Mr. Abedin for 8.
And my learned friend is 2.
This interlocutor application referred by the applicant, the order 1 to 10 of the Code of Civil Procedure, read it section 151 of the court for impleading the applicant as respondent number Respondent number 9. Respondent number 9 in WPC number 4498.
Copy.
Mr. Das learned counsel for the applicant submits that the applicant is the necessary party in the proceeding. And as such, he has to be pleaded as a respondent number 9.
8, well, will be 8. That's respondent number 8.
In
Because in repetition up to
8, my lord.
8.
Eight.
Respondent number 8. Respondent number 8 in WPC number 4498.
4498.
Mr. Teka learned counsel for the respondent number 1. That is the ability for respondent number 2. So, start. Open for respondent number 2. So submits that they have no objection in the event of implementing the applicant as respondent number 8 in the definition. Accordingly, taking note of the submission of learned counsel for both the parties. Also, considering the facts and circumstances of the court, this interlocutory application stands allowed. The applicant be pleaded as respondent number 8 in WPC number 4498 of 2024. In view of the order passed in the IA, Mr. Teka learned counsel for the petitioner shall file amended first title in WPC number 4498 of 2024. And release the matter.
My lord, for admission hearing, my lord, any date, lordship. In the first week of November, my lord. First week of November, my lord.
First week of
November, my lord.
Well, I have to file affidavit.
In the meantime, let him file affidavit, my lord.
If there is, if so, advance.
On 10th November.
10th of November.
My lord.
In the meantime, Mr. Das learned counsel for the newly implemented respondent number 8 shall file his affidavit.
Yes, my lord. Deeply obliged.
Second week of November, madam, will do better.
On 10th November.
Second week.
Second.
10th.
10th November.
Obliged.
22.
Ma'am, please. My lord, in this case, I'm appearing on behalf of Mr. K. Gogoi for Dibrugarh University, my lord. He needs some time to file affidavit for Dibrugarh University.
Huh? Heart is that?
Yes, Soma, my lord.
Yes, so learned counsel for the petitioner. Sir, S plus learned counsel appearing on
behalf of
Sir
K.
K.
Gogoi.
Gogoi, learned standing counsel for the Dibrugarh University. Standing counsel.
K. Gogoi is standing on.
Standing counsel for Dibrugarh University. Pressed for granting some time to file the affidavit in a court. Where is about? This is always the method. When?
Hello, 2 weeks.
2 weeks. After 2 weeks.
23. Deeply obliged.
May I please, Lordship? Lordship, in this case, respondents are supposed to file affidavit on
Instructional lottery. Need some more time.
You are for?
I'm for the forest department lottery. Respond
Forest
number
department.
1, 2, 4, 5, and 6.
I am appearing for health department lordship. Okay, we have received instruction. Okay, regarding the reimbursement bill, we have already sent back the matter to the forest department lordship. The instruction.
Okay, you file your affidavit.
Very well.
Heard Mr. Mohanto learned counsel for the petitioner and Mr.
R. Gogoi.
R.
Gogoi.
R. Gogoi learned standing counsel for
Forest
the
department.
Forest Department and Mr.
You host
You host
On
learned
behalf of
standing
DP Board of
You host learned counsel appearing on behalf of Mr. TP Board.
DP.
Learned standing counsel for the health department. Being number 3, 7, and 8. Of both the counsel for the respondent, price for granting some time to file affidavit in opposition as the instructions are being awaited. Accordingly, it is provided that this is the method after 2 weeks. After 2 weeks.
Lordship, I am appearing for 7 and 8 laws. So this is not for 6.
In the earlier order, it is reflected that you are appearing for 3, 7, and 8. Confirm report.
Item 39.
May I please, your lordship? Lordship, he has already give me the instruction last occasion, my lord. As per that instruction, prior to that, my lord, kindly take my affidavit, second affidavit, my lord, filed on 9/2/2025. I just point out 2 points, my lord, only 2 points, my lord. On my lord, 28 August, my lord, annexer kindly turn to page 128, my lord.
On the other day, Mr. Das said the obtain instruction.
Yes, yes.
and copy
Yes,
of
yes,
the
yes,
same
yes.
was furnished to you.
Yes, yes. As per that instruction, my lord, here the principal of this has clarified that 3 posts is laying vacant in respect of the mechanical department and 1 post is laying vacant in respect of the civil engineering department, my lord. And now, my lord, my submission is that kindly take this instruction, my lord, what he has submitted on last occasion, my lord. In their instruction, my lord, kindly turn the next page, my lord. Instruction dated 24th September 2025. It is stated that, my lord, second page, very top of the page, my lord, the rest 4 posts are laying vacant, out of which 1 post in the Department of Civil Engineering and 3 posts in the Department of Mechanical Engineering are laying vacant. The department subject wise list of regular incumbents as submitted by the principal gist was also annexed with the instruction, my lord. And kindly turn to next page, my lord. This is the annexer, my lord. This order has been passed by the director on 13/12/2024, and he has already one foreman's committee has been arranged, my lord. On the committee was suggested to verify the total the present status of the gist, and accordingly, my lord, in the next page, my lord, the committee has submitted the report, my lord. In that report, my lord, in the first page of the report, my lord, annexer 2, as per his instruction, my lord, I am reading the relevant portion, my lord, only.
Which is the instruction of
This is instruction dated, my lord, he has submitted only 24th September 2025. So, instruction to last. Yes, I think they do it. Ini juga. Oh, baik. Kita jelas ko dia. Kasi jelas ko dia.
which page of the instruction you were referring to?
My lord, in the page number 1, my lord, accordingly 1, 2, 3, 4th page, my lord. This is the number 1, page number 1 out of 8. Not first page, my lord. After
There is only 3 pages.
3 page. This is the instruction dated 24th September 2025. Extra copy আছে নি? এবার বাচ্চা কোড দিবো হেরি নয়ন সব কপি দিয়ে দিচ্ছি দিয়ে দিন ভাই
I am already sent the soft copy method. Okay. Your second file is in there. Yes, yes, the annexer 2, my lord. In the this instruction, my lord, in the second page, it was clearly stated the 4 processes laying vacant, 1 in belongs to the civil engineering and 3 belongs to the mechanical engineering. And this is the report, my lord. Issues relating to the Jorhat Institute of Science and Technology, my lord.
At page number.
Page number, my lord, there is no any regular page number. That is after leaving the 3rd page, 4th page, my lord, of that instruction. Annexer 2. No? Issues relating to that is, my lord. I am reading the chronology of the event first, my lord. In the middle of the page, my lord. A, serial number A, chronology of the event. Year 1971. Jorhat Science College was established in the year of 1971 as a degree science college with a course of so and so, so and so, so and so. First, my lord, in the year of 1971, my lord, this college was established as a science college. Thereafter, my lord, kindly turn to page 3 of that 8th page, my lord. Yes. That is serial year 2008, serial number 6, my lord. In the year 2008, first paragraph, my lord, top of that page, my lord. In the year 2008, by notification number so and so, dated 18 November 2008, Jorhat Science College was converted to the Jorhat Institute of Science and Technology. 7. Government created 50 numbers of posts for this by letter number so and so, dated 22/8/2008, and the sanctioned posts were as stated in the table below. It may be noted that the post of the professors, assistant professors, and lecturers were not segregated branch subject-wise and was under the Technical Education Department. Year 2009. Next, my lord, after the table, my lord. Initially, after conversion from Science College, these 2 branches of engineering, my lord, namely electronics and telecommunication, and power electronics and instrumentation engineering, PEI, were started in GIST. And now, my lord, kindly turn to next page, my lord. Next page, my lord. That is their instruction, my lord. Year 2016, my lord. Serial number 17. The BTech degree course in civil engineering and mechanical engineering had started in GIST from 2016. Engineering and mechanical has been started in the year of 2016, not from the 8th, my lord. In the year of 8, my lord, 2008, my lord, only 2 branches were started, my lord. Next serial number 18. The government of Assam by notification number so and so, dated 13 December 2016, temporarily placed the service of the newly appointed 14 numbers of assistant professor under GIST society. That is done. And thereafter, please turn to next page, my lord, page 5. Heading is the issue identified. B. Serial number 3, my lord.
No,
No, I am coming to the class of the. Yes, yes. I am coming to the class, my lord. I am coming to the class. What he has submitted, this is for totally cannot be accepted. My lord, these 2 points are very vital, my lord. Kindly see. Two points, my lord, only. Number 3, serial number 3. In the sanctioned post of the professor, associate professor, and assistant professor were initially created for 2 branches. My lord, 37 posts were created in respect of the lecturer. That 37 posts were initially created only for that 2 branch, my lord. ETC and power electronics, my lord.
That is their instruction, my lord, only, namely electronics and telecommunication engineering and power electronics and instrumentation engineering, which were not segregated branch-wise. And next, my lord, in the year 2016, when two new branches of engineering were started, that is civil engineering and mechanical engineering, no additional posts were created. That means, my lord, as till that, my lord, no post has been created and no segregation was created. Post has been created formally, my lord. One sanction post, my lord. There's a government sanction post, my lord. This is their snapshot, my lord. In that, sanction post can be converted to another ones with the approval of the government. That has not been done, my lord.
We will not go into this nitty-gritty.
My lord, my contention is that, my lord, according to them, 4 posts is laying vacant, mechanical and civil. Initially, my lord, that entire altogether, my lord, 37 lecturer posts. That means assistant professor posts were sanctioned by the government. Out of that, my lord, in lordship will come kindly see for the time being, my lord, as per their letter, my lord, lordship will clear it then. In my additional affidavit number 2, page 136, my lord. I am coming that point, my lord, only. Initially, when in the year of 2028, what was happened, my lord? Page 136, my lord. This is the table, my lord. Serial number 4, lecturer, electronics and telecommunication engineering, 12, my lord. And serial number 7, lecturer, power electronics and instrumentation, 12, my lord. And that 24 post has not been segregated by the formally, my lord. Our post has not been formally segregated. In the year of 2016, these posts were filled up by the mechanical engineering professor lecturer and mechanical civil engineering lecturer, my lord. That has been done, my lord. And in their instruction, it is clearly stated in issues identified in page 5 of this instruction, my lord. It is said no new post has been created till date, my lord. And initially, those posts which has been already created in respect of the 2 branches, my lord, these are the electronics and telecommunication engineering and power electronics and instrumentation engineering. And now, my lord, the remaining posts are not belongs to the civil engineering and the mechanical engineering. They are the originally created posts in respect of that 2 branches, my lord.
No, that is not the issue before the court. We will not go into this matter.
That's why, my lord, my fear is that, my lord, the post is laying vacant, my lord. This is our post, my lord. And we may be allowed to continue, my lord, as per the cabinet decision, my lord. They have to appoint us in the TF. But they did not appoint us. Now, my lord, vacant post is already available as per their instruction. These posts are initially, still, my lord, these posts are not segregated by the government, my lord. Since these are the posts laying vacant, my lord, since these posts were initially created in respect of that 2 branches, my lord, we may be allowed to continue for 4 months, my lord. As per the cabinet decision, my lord. Only 4 months period, my lord. These are posts are not still advertised, my lord. These posts were not advertised.
Yes, Mr. Das, why there is a discrepancy in your written instruction?
My lord, before that, my lord, what my learned pen has shown to this honorable court, my lord, is page 5, internal, my lord, issues identified. Those are the issues identified by the, my lord, authority. It's written as per allegations, complaints, RTIs, the main issues as these are. Page number, page 5, my lord, internal 5 of issues identified. Thereafter, after allegations, complaints, and RTIs, those issues were identified by the authorities. Then, my lord, kindly to the next page, corrective measures by the suggested. Corrective measures suggested. Point number 3, branch-wise segregation of existing sanction posts, which was never done now needs to be done as per student faculty ratio of 1:20 as recommended by AICTE. Accordingly, one post of professor and one post of associate professor may be created in each of the branch of civil engineering and mechanical engineering. Further, it is proposed to divide the existing sanctioned post in the engineering stream as follows, as stated in the table. Now, this is the segregation of the table. This is the segregation of post post subject wise or department wise. And as per this table, but there is no vacancy in the post which in which subject the petitioners have done their degree. At present, only civil engineering and mechanical engineering posts are vacant. However, whereas the petitioners have done their degree in the electrical engineering and electronic and communication engineering. And what my friend is speaking, he wants to change the structure of the branch wise or department wise post available or created by the this the college authority. Now he is seeking that he is claiming, whether rightly or wrongly, he is claiming that these posts were held by the petitioner. But that is different cause of action. For that, he has to claim whether those posts were originally occupied by him or not. Now, at present, my lord, the post lying vacant is only in the branch of civil engineering and mechanical engineering, and the petitioners are not belong to that department. They are belonging to electrical engineering and electronics and communication engineering.
The table, but he is relying, my lord, this is only proposed, my lord. That proposal can be come to the finality after getting the approval of the government, my lord. It is not done till date, my lord. Nowhere it has been stated in the instruction, my lord. Because it's a government created post, not the director created or college created post. This is only the government has the prerogative in respect of the creation of the post, segregation of the post, so and so, my lord. And there is no any approval. And since, as per their instruction, since initially these posts were created in respect of two branches, my lord, without the segregation approval from the government, already filled up in respect of the civil engineering and mechanical area. And now, my lord, mechanical engineering posts were laying vacant. These posts are originally belong to the.
You say these are disputed question. Petition, we cannot decide the same. You are claiming that some posts are there in electrical and communication engineering. When he submits that there is no post. Can
That
we
is true, my
decide
lord.
that issue?
My lord, actually, what happened, my lord? One proposal was submitted by the principal, my lord. That in that proposal, my lord, I have annexed. In that proposal, my lord, principal has said in respect of the. Lordship will find my second affidavit, my lord. In ETC, my lord, that is at page 137, my lord.
Let us do one thing. We issue direction of Mr. Das.
Hello.
Verify if there is any post in the department. It's available that open it for months.
That direction can be issued, but another thing is that
You verify if it is there, then you appoint that. If it is not there, then what?
The thing is that this scheme is not there right now. So that by which scheme the 100 incumbents were engaged under 3F, that all been terminated because now this scheme is not available. Directly if available or if the authority desires, they will take. if he can be.
And my lord, one thing maybe also observe, my lord, whether the segregation has been approved by the government or not, my lord.
No, no.
No, that
we
is another.
cannot go into,
He can approach this court for that.
that is not the issue before the court. There is no statement or environment in your petition or in your affidavit.
My lord, actually, whatever, my lord, this instruction has been provided to me only last occasion, my lord. After filing my second additional affidavit, my lord. All the documents what he has submitted, I have bring to the record, brought to the record, my lord.
Okay, we will dispose of the petition by directing them to verify. If available, they will appoint. If not available, then what?
Okay, sir. All right, sir.
Coming item 4. May I please your worship? I have received some verbal instruction. One inquiry was done, but one inquiry was done. But this suspension order was not reviewed.
Review.
Not reviewed.
Then definitely it will go. You obtain a written instruction and place it on next date. Yes.
My lord.
Third, Mr. A.M. Bormuya, learned counsel for the petitioner and learned respondent in department. During the course of hearing, Ms. Okon was directed to obtain instruction as to whether suspension order dated 17/8/2024 was reviewed within the period of 90 days or not. And Ms. Okon obtained verbal instruction and apprised this that the suspension order was not reviewed within the period of 90 days, but one inquiry has been done.
Yep.
Accordingly, it is provided that Ms. Okon shall bring on record the verbal instruction by filing an affidavit on next date. This is the matter on 24th of October.
What, my lord, he may bring, my lord, written instruction. Affidavit or written. And kindly, 40, kindly, my lord, any date may be fixed one.
Already fixed, 24th.
Development.
Development. Your lordship, lordship, the respondents were repeatedly directed to file an affidavit, but lordship, the respondents have failed to do so. If my lordship peruses the order dated 18/9/2025, they were strictly directed to file the affidavit, failing which the concerned respondent officials shall be personally present in the court. Thereafter, the matter was listed on 25/9, on which date they again sought for time, your lordship, to file affidavit.
May it please your lordship. Lordship, what has happened actually, my senior Mr. A.K. Bhuya, he has been newly appointed as pending counsel of PTC lordship.
Pardon?
My senior Mr. A.K. Bhuya, he has been newly appointed as pending counsel of PTC lordship on 14th of this month. But we need some time, but we do not have the records with us.
But my lordship, they have been repeatedly seeking time, your lordship.
So if the council has been sent, then what?
Yes, lord. Lordship, the petitioner will also retire the next year. It's a long pending matter, lordship.
Well, we'll try to dispose of before it's here. Third, Miss, your good name, please.
J. Sharma.
J. Sharma, learned counsel for the petitioner. And Mr.
Zedar, on behalf of Mr. A.K. Bhuya.
J. Das, learned counsel for the
Lordship,
learned counsel representing behalf of A.K. Nothing for the respondent, PTC. Mr. So, learned counsel representing on behalf of Mr. Bhuya, said, Mr. Bhuya has recently engaged in this case, and as such, the affidavit could not be filed. Affidavit in opposition could not be filed, and that for this matter after 1 week or 2 weeks. 2 weeks.
lordship, a date may be fixed. Kindly a date may be fixed.
Where is accordingly adopted, let's submit the matter on
10th November.
10th of November.
Obliged.
Obliged, Lordship.
Timing item 11.
The cartoon here,
Sir, actually today I am not ready.
someone appears on your behalf and submits that you are praying for time.
Yes, well, today actually I am not prepared, that is why.
So when we can raise the matter?
Any date in the first week of November, my lord.
First week of November.
Subject to his convenience, my lord. 5th or 12th, no? 5th or 12th.
Fifth is holiday for 12. Fifth is a holiday, November 12.
Then 12th, my lord.
Okay. As agreed by learned advocate of both the parties,
Wednesday.
this is the matter on 12th of November as part.
Obliged.
Item 41.
May I please, Your Lordship? Matter relates to the disciplinary proceeding, Lordship. Petitioner was initially arrested in a police case. The police case already dropped against the petitioner, Lordship. But the disciplinary proceeding is still continuing. Petitioner as such submitted various representations to drop the disciplinary proceeding, Lordship. This is the case. There is no criminal case as such already dropped in the charge sheet itself mentioned that nothing has been found against the present petitioner. Accordingly, he is released from the allegation.
Where is inspection?
Awaiting inspection.
Everything.
Last two occasions they have taken time. Lordship. The basis of the criminal case, nothing against the petitioner already dropped against it.
To complete the CP within time frame.
How they will complete the DP, Lordship, on the basis of the criminal case which was registered against the petitioner. Petitioner already acquitted, Lordship, at the time of filing the charge sheet, Lordship. Nothing, he is dropped against the criminal.
He was not charged in the
Charge sheeted, acquitted, Lordship. They have released from the allegation. He is on mistake on the part of the police authority. He was arrested in a criminal case, Lordship. In this regard, petitioner also taking necessary steps regarding the compensation against the investigating authority. Why they have arrested?
You tell me whether you are really interested to file affidavit in opposition or not.
That personally I cannot say, madam, because instruction is
No, on that ground you will not.
There is no witness, nothing. How they will complete the disciplinary proceeding, Lordship? Criminal case already is exculpated from the criminal case, Lordship. They have itself mentioned in the charge sheet also.
I leave it to madam.
Nothing, Lordship, just harassing the petitioner, Lordship. They have written.
Pardon?
I leave it to this honorable court.
My one prayer, Lordship, at this stage, in the interim, Lordship, disciplinary proceeding may be stayed, Lordship. Last occasion, Lordship also mentioned in the last occasion, it is also.
On what ground will stay the proceeding?
Lordship, my ground is that in the charge sheet, Lordship, petitioner dropped from the criminal case. There is nothing. This is
Case, you may be acquitted, but they have the right to proceed against you.
Yes.
Lordship, when the petitioner was arrested in a criminal case, Lordship, the witnesses will be same. The basis of the allegation is the same, Lordship. Everything will be same. Police investigation already concluded. They have submitted the charge sheet where nothing has been found against the petitioner. So now, only, Lordship, they will delay on the matter. How they will complete, Lordship? In the show cause notice, what allegation they have mentioned that this is the connection with the criminal case, Lordship.
My lord, last time maybe given to taking. New method.
Lordship, kindly see page number 47. This is the show cause was issued to the petitioner, Lordship. Where they have statement of allegation, they have mentioned that the petitioner was arrested in a TUPS case number so and so. This is the main allegation. In this allegation, he is already, Lordship, acquitted. In the charge sheet also, investigation authority mentioned that nothing has been found. He is wrongly arrested, Lordship. Only one statement of allegation, page 47. This is the petitioner was arrested in a connection of TUP, nothing else there.
Heard Mr. A.B.T. Hope, learned counsel for the petition. And Mr. D. Pego, learned standing counsel for the respondent in human services department. Mr. Pego submits that. So, by order dated 15/9/2025, standing counsel was directed to obtain instruction. The same has not yet been received. Then he applies for granting him last opportunity to produce the written inspection before the court fair is accordingly allowed. Respect that the matter on uh, 6th of November. Then in the event of failing to produce the inspection to this court on that day, the court will consider the interim care of the petitioner. Please accordingly.
Obliged.
Item 26 for orders.
Yes, Lordship, here the director has already sent a proposal for case on one post for permission of the service of petitioner, Lordship. Now, the secretary has again written a letter on 16/10 to send a fresh proposal, Lordship, for increasing the budget provision for the financial year 2025 and 26. So now the fresh proposal will go within the next week, Lordship. The budget proposal has to be for the current financial year.
Mr. SM is present. Then, sir. 16. Has produced a letter dated 17th of October 2025. Which he has received from the Joint Director of Elementary Education. Then, and submits that. The office of the Joint Director has already issued a letter to the government on 11/3/2025 creation of one post of tutor for realization of service in respect of the petitioner. But the government has directed to furnish fresh proposal indicating the budget provision under appropriate head of accounts for the financial year 2025-26. And the financial implication by letter under reference dated 16/10/2025 and under such circumstances, sir, this submits that the proposal will be sent by the government by next week.
No, by the director to the government.
By the director to the government by next week. And a press will listing the matter after 2 weeks. 2 weeks. After 2 weeks. Accordingly, it is provided that register will list the matter after 2 weeks. The letter produced before the court today has been marked as letter A. That will be to the record.
Lord, kindly peruse the last order, matter.
Yes. The director has written to the secretary for creation of a post lawsuit for formulation with the service of the petitioner law. Now matter is pending before the secretary party association.
Secretary, director.
Huh?
Director.
Secretary is not a problem.
But my lord, direction is to the director to provincialize.
Yes, director alone cannot, lawsuit director can send the proposal to the government. Government has to approve, then it will go to the finance for the creation of the post. And accordingly, lawsuit, it will be created. It will be provincialized process.
The question is, when we will be able to complete the entire process?
Because of this for creation of the post, it will go to the finance. Ultimately, finance will have to sanction it. And the government and finance, they are not party before this honorable court. And the director can, even in the act itself, the director can alone cannot commercialize lawsuit. They have to send it to the government for the approval, then post has to be created, then it has moved finance department lawsuit. So that will, it is on the, but it is not that there is no deliberate lawsuit, the violation that they are not intended to imply. They are going to imply compliance with the honorable court order lawsuit.
It is order of 9/2/2024.
No, this order was produced on the other day.
This was.
Yes,
Yeah.
on 26/9 it was produced.
Earlier, Mr. PK Bora, he is today he is due to personal difficulty, he has not come, though he has requested me. So that information I don't.
With the same letter, you were again trying for time.
Oh, that information I don't have. Lawsuit may kindly fix it on immediately reopening. Because PK Bora, he has due to his personal difficulty, he is not present today. On Wednesday, lawsuit kindly fix it out.
So, sister, this is not a way of handling this in contempt cases by the government.
My lord,
Today you are appearing on that day, someone will appear. Then these are the reasons for behind tendency of large number of repetitions relating to this.
Not in all cases.
that is why, my lord,
In most of the cases, we try to assist the court, and in fact, we are assisting it. In some cases, they are difficult because of personal difficulty, he has not appeared to the lawsuit.
only to
It is not that in all the cases we didn't assist the court.
in one case, one of my case, my lord, yesterday, his provincialized service was provincialized order of 2022. Now person is getting only 15 days. This month he will retire. Just before 15 days, he was provincialized. In my case, yesterday, my lord. So same thing will here also happen. Just given 15 days time to provincialize service. After 15 days, he will repair. Only this month, my lord. A order has been passed by this court, honorable court, in 2022. Same thing will here also, my lord. Only their intention is to delay. Nothing else, my lord. In all cases, my lord. So far, I am concerned, my lord. It is order of more than 1.5 years, my lord.
Not only in contempt matters, but in other matters also.
Also, same thing.
One council appear on one day, other council.
That is because of the large number of cases against the education department lawsuit. We have only few councils. Otherwise, cases are on very large lawsuit.
No, that's all right.
That is the difficulty. Otherwise,
mean that you have to change them on each and every day. Why there is no consistency?
no, because of large number of cases, it is difficult to keep track lawsuit who is appearing on a last date lawsuit.
So sometimes it happens, Lordship.
That is your business, that is not our
Yes.
business. But this practice is deprecable. On 26/9.
Yes, sir. Well, these cases, I'm not.
Letter was produced
Yes,
by
no,
Mr. Bora.
yeah, that is why, Lordship, I am not facing this communication right now. Lordship, we can see on Wednesday, Lordship. Let the boy appear in it.
Third Mr. Controller, learned from Court of Petitioner, that SFSSA appearing on behalf of Mr. Bora. DK Bora, learned. Conflict product of Mr. Assistant submits that this matter was assigned to Mr. Bora, and he is not present in the court today, and request for the second matter on 22nd of October.
Yes.
Accordingly, it is provided that the solicitor will list the matter on 22nd of October, so as to enable the council to produce the compliance order before this court on Friday. In the event of failing to produce the compliance order, the court will consider directing the contemptor to remain personally present before this court.
My lord, may I pray at 2, my lord? At 2, my lord, may I pray? May I pray at 2, my lord?
Why?
My lord, otherwise, sometime it is not reaching, my lord. Let it please come 22nd, then he pray for. Earlier,
Okay, at 2 p.m.
I am DPO. Timing item 10.
Maybe. In this case, I have seen the record also, Lordship. And from the record, it says that they have verified in 2009. Selection was made in 1999. I was appointed in 1999. I worked for some time. And in my list, which I have submitted, my name is there. That is also a similar writing is there. It is verified with the original one that is written there. One sentence, Your Lordship, can be page 25. Yes. Only one, As you Lordship got it. Below my reference side, certified and verified with the original photo records of this directorate. That is not, it is also similar writing is there, and they have not produced the original one, but is the copy of the photostat copy which is certified as a from the original, but not the original . And as per law Evidence Act number section 58 or 59, original only that is accepted by the petitioner. And so from the record available, so I want to consult with my client because they are also some so my prayer, it may be taken after some days, so that I can consult with them and Your Lordship will pass the final order. Other than that, they will question me against this.
Heard Mr. Rosit, learned counsel for the petition. Technical counsel for the respondent. Payment paid to the department. Person to direction of this court, Mr. Sharma has produced the original file from the department. And referring to the election list, Mr. Sharma submits that the name of the petitioner finds no mention in the list available with the department.
And
That is it, Mr. Rosit submits that he may be granted some time to obtain instruction from the petitioner. Where is accordingly allowed, let's submit the matter of
On 10th,
after
10th November.
10 November.
One sentence, Your Lordship, my prayer, Your Lordship, that the copy who is produced by my learned friend, that is the photocopy verified with the original, and my own is same. So his copy, is original, photostat copy verified from the original, with the original. Yes.
That is available file.
No, that is not.
But Lordship has already observed that record.
If you observe, then okay, my lord. Must.
In that case, may I return back the record?
No, details of file.
Lordship.
the file produced before the court to also retain till disposal of the case.
Coming at 19.
May it please your lordship. Lordship, in this matter, praying for a short accommodation as my senior has been to trial court as he couldn't return on time, your lordship.
How many adjournments you have taken?
That I understand, your lordship. Senior have to come and have to appear in this matter, your lordship. But as he couldn't reach on time, as that will take a
If
little
you are
longer.
not interested to pursue the matter, okay, you withdraw it. May I see your good name, please?
M. Zomanpui. I'll write down
Learned
my.
counsel appearing on behalf of Mr. B.D. Poor, learned counsel for the petitioner submits that Mr. Poor is in the trial court and therefore he could not reach the court in time, this court in time, and press for testing the matter of some other date. There is a lot of the matter.
Lordship, if possible, this
Correct.
matter can 28. Surely this my senior will appear on that date.
28.
28.
Okay, 28.
Obliged. 28 October. Highly obliged.
Item number 27 for order.
And it is on behalf of respondent number 5.
None appears for the petitioner as well. How, Miss, your good name, please?
JK Pathak.
JK?
Pathak.
Pathak. So, respondent number 5, present. You for? Your name, please?
Yeah.
Learned counsel for the respondent number 3. Mr. Das is here? Yes. Respondent number? 1 and 2 present. In the event of subsequent non-representation of the petitioner, appropriate orders will follow.
28.
In item 38 lawsuit, the secretary has already issued an order in compliance with the honorable court and directed the director to place the matter before the state level selection committee. And accordingly, the matter was placed before the state level selection committee by the director of lawsuit. Then the state level selection committee, while verifying the record, has found some mismatch in the statement of the claim of the petitioner. Then now the a report has been sought from the DO, lawsuit, DO and BO, and it will be placed before the SLC again after receiving that report lawsuit.
Ordinance a copy to him.
Yes. And direction was that if the respondent direction was let the appellate they have to file appeal lawsuit and direction was that lawsuit if the concerned appellate authority after hearing the parties come to the conclusion that if the petitioner whose service have been provincialized, her service shall be provincialized and she shall pay her salary lawsuit. If she found to be working regularly. So it was the compliance, the secretary has issued that compliance order and the director has placed it before the SLC. The SLC found that some statements were mismatched. So a report has been sought from the district lawsuit. After receiving that report lawsuit, it will be placed again before the SLC for its final consideration. Will tell you it.
Oh, who is the
Appeal report is written.
One new point has been added here, my lord. The respondent number 7, my lord, is stated to have joined, my lord, on 9/1/1994, which was not recorded in the district level scrutiny committee, my lord, in the minors.
That is why there's some
Now,
risky-
just first time, my lord, this sentence has been added.
This is as per the DO report of the DO. Some misplace has been reported what is the claim of the petitioner, statement of the DO, a record of the school lordship.
And even, my lord, in the order, my lord, dated 16/8/25, my lord, it is said that Afruza Khatun had joined on 3/3/1994 and the private escort number Nasiruddin Ahmed joined on 11/6/1996, my lord. As such, the petitioner Afruza Khatun is senior to the private escort number Nasiruddin Ahmed. It is also revealed from the report of DEO Assam that Afruza Khatun taught Assamese subject and Nasiruddin Ahmed taught English subject. And as such, both are language teachers. However, it is seen that the above aspect was not duly considered by the SSLC.
That was exactly what is the direction order of the secretary reflected lordship.
So I joined, my lord, on 3/3/94 and respondent number 7 joined on, my lord, 11/6/1996. This is the first time, my lord. Now this one line has been added newly, my lord, in this order. Anyway, my lord, let them complete the process, let them come to logical conclusion. If I am agreed, I will challenge again, my lord. But at least this process be completed, my lord. Logical conclusion.
In fact, Lordship may kindly peruse the order dated 16/8/2025 with the Secretary of School Education. In the first page, last Lordship, exactly reflected what my learned friend has submitted, Lordship. That our petitioner Afzal Khatun has joined on 3/3/1994 and the private respondent Nasiruddin joined on 11/6/1996. That is what my learned friend has submitted. And this is added because the DO Gwalpara has submitted a report on 15/9/2025, on 15th of September of this year, Lordship, where this particular Lordship, this response 7 has joined on 9/1/1994 was written by the DO Gwalpara. So that is why these things has arrived.
My lord, kindly see page
It is
22.
not the director has written it, not
I-
or director has added it.
Page, my lord, kindly see 22, my lord, relevant portion, my lord, of my contempt petition. Page 22, my lord.
Yeah.
22, my lord. This is the minors, my lord, by the DLC, my lord. That is 96 serial, my lord, Gosaidubi MEM. From the below, my lord, third number. Nasiruddin Ahmed, headmaster. His name was proposed as headmaster, my lord. Respondent number 7. Joined on 11/6/1996. And Afruza Khatun, language, my lord. He is for headmaster and I am for language subject, my lord. I joined on 3/3/1994, my lord.
This is exactly reflected in the order dated 16/8 of the Secretary of
Yes.
School Education, Lordship. In the order dated 16/8, this is exactly reflected, Lordship. Only after that, the DO has submitted the report on 16/9 on subsequent month, Lordship. It stated that he has joined on 11/9. That's why this 9/1/19 report. That is why this discrepancy has arrived. Otherwise, in the order dated,
No, that is in respect of another person, Nasiruddin.
the response of 7. He is the response 7 of that in writ petition, Lordship.
No, we are concerned with Afruza Khatun.
Yes, Afroza Khatun has filed this writ petition challenging that compliance of Nasiruddin Ahmed Lordship. The both they were both language speakers.
My lord, his name, my lord, came up for the post of headmaster. When he has seen that there is no post of headmaster as such, my lord, then he used to claim, my lord, as a language teacher, my lord, that I took English, I taught English, and she taught Assamese.
It is a dispute between the petitioner and Nasiruddin for the same language, for the language, same post having the language teacher.
So now, my lord, what is left is, my lord, I joined in the year 1994 and respondent number 7 joined in the year 1996, my lord. And even if, my lord, it is assumed that both are these language teachers, my lord. Now, my lord, let us come to the joining date. Then I am senior in the year 1994 and he joined in the year 1996. So in all, my lord, still I am entitled. Now this one sentence, my lord, it has been all along the, my lord, consequential orders and everything, my lord. Now this sentence is.
Which sentence you were referring to?
In the second letter of the director of elementary dated 16 October Lordship, that the DO Gwalpara and the third paragraph, Lordship, third paragraph. DO Gwalpara submitted report by letter number so and so dated 15/9/2025, including the original proceeding book of SMC. From the resolution of the SMC, it is stated, resolution of the SMC, it is stated Nasiruddin Ahmed, the response 7 was appointed on 9/1/94 as agent teacher and he joined on 10/1/94. 10/1/94. That resolution shows that the representative has joined prior to the petitioner. So that discrepancy arises. Now, all along, even in the letter compliance order that the secretary lordship that it is shown that Nasiruddin has joined on 11/6/96 and Afruza Khatun petitioner has joined on 3/3/1994. Now the DO from the original SMC resolution book, it is shown that the respondent 7 joined on 10/1/1994. This is prior to the petitioner. So a discrepancy arises, lordship. That is why hearing was called for.
And now, my lord, this one sentence, my lord, used by the DEO, my lord, will vitiate the entire process of the district scrutiny committee. Now, he is the new incumbent. So what is the source of this one line, my lord, that he has?
That's a resolution,
put in the text?
resolution book. It is clear, it in here, Lordship, from the resolution of the SMC, it is seen that so-and-so has appointed by the SMC on 9/1/94 and has joined on 10/1/94. The resolution book.
Maybe, my lord, this is, my lord, subsequent
That is why
development,
hearing-
I do not know, but if I am agree, my lord, then later on, my lord, I will, if so advised, I will, my lord, challenge it. But let them come to the logical conclusion, my lord.
Third, Mr. A, F, and Q model learned for the petition. Learned complete product of Mr. Sisty has produced one issued by the Secretary to the Gopal Basant Department of School Education. School Education, and also one letter of the Director, Elementary Education, Kailipara. And on the strength of the same, he submits that the matter of the petitioner was placed before the SLC. And the SLC, after verifying the record, found that there is mismatch in the statement of the claim of the petitioner in the writ petition from a report of BEEO and record of school SLSC decided. Now, and therefore the SLSC decided to conduct a hearing of BEEO and BEEO of a petitioner as well as respondent number 7, Nasiruddin Ahmed, for a clarification and place the matter before the next SLC meeting for taking a decision. And he pressed for granting some time, that is accordingly allowed. That's the place the matter after 2 weeks. Yes. And in the meantime, Mr. Sisty shall update about this and apply this for the next step about the process.
Apply it.
The letter for this report today shall be marked as the next 30.
Let's say for a date, my lord. Okay.
14th November.
14th.
10th November.
Published.
Item number 29 and item 1 of production. Lordship, this IA has been filed today. Annexing the service report regarding the completion of service. This petitioner is deprived from pensionary benefits since last 2 years, Lordship. Despite receiving notice, they are willfully not appearing before this court, Lord.
This IA is for what purpose?
Lordship, in the IA, we have annexed the service has been complete, Lordship. We have
Okay.
annexed the tracking report, Lordship.
Okay.
But still they are not appearing before this court, Lordship. And the petitioner has been deprived from pensionary benefits since last 2.5 years, Lordship. So shall I annex the tracking report in Annexure X, Lordship, page number 10.
Pardon me, sir.
S Sarkar, Lordship.
S.
Sarkar.
Sarkar, Learned Council for the application. Enter the file.
Lordship may issue deductions for their appearance, Lordship. Because the petitioner has been suffering since last more than 2 years, Lordship.
For directing the consumer to personally appear before this court and to explain why it is not be punished for contempt of
Higher education of the Assam University.
by way of deliberately disobeying the order Judgment and order dated 16/2/2020, authorized its court in application of our court.
Petition number 4301/22.
Where is it in your?
Lordship, he is annual today, so he went. So I have to move this petition today. He was in the first half, but he felt unwell, so he is not available.
Instead of IA, this should have been additional affidavit that you have effected survey.
Lordship. Lordship may fix it on any other day. Lordship may fix it on any other day if Lordship.
Oh, we'll take it up on different date. Let
Lordship.
your senior remain
Lordship.
present.
A short date may be given, Lordship. Immediately after opening.
The pair being made by Mr. Suresh. This is the list of matter on
23rd, Lordship. I love Lordship.
Matter number 30. This is regarding family pension, my lord. Long pending, my lord.
In fact, here office director has already submitted the papers to the director of pension on 11/3/2024. Thereafter, the pension department got some queries, and thereafter, Lordship, the DO Sikshaka has already on 8/9/2025, Lordship has sent that a letter to the director of pension. That letter, Lordship, I'm unable to get it today, Lordship. But it was resubmitted to the director of pension, Lordship. Lordship, I can take it after 10 minutes, Lordship, if I get it. Yes.
Item number 31.
May it please your lordship. Way back in 25/6/2025, there was a direction, your lordship, to file an affidavit.
Here also, Lordship, PK Bora appeared, Lordship. I'm extremely sorry for that.
And
My lordship,
lordship may kindly peruse the last order
Otherwise,
also.
I haven't, in fact, I have get instruction in the group, Lordship. Lordship, can you peruse it?
In this case, the court has already settled the matter, finding me eligible for the post. Only the SLC has to do the procedural work, giving me the appointment order. And that order, which is under challenged, it is passed way back more than a year ago, your lordship. We are in the fourth round of litigation.
এই report থেকে দিব পৰা clear ন দুজন মানুহ আছে ডিম্বেশ্বৰ গগৈ দুজন মানুহ এইটো
There is order is specific, Lord Dimbeshwar Gogoi, for the petitioner, they have to decide, give me the appointment. And for
Only the difficulty there found to be two Dimbeshwar Gogoi in the district, Lordship. Which one is that petitioner, Lordship, that clarification, that clarity has not come, Lordship, from the district.
That is the difficulty. Father's There is name and two petitioner in the name of Dimbeswar Gogoi. father's name and everything is given, your lordship. They are not identifying the petition. Can this be a
That clarification from the DO has to become, Lordship, that it is not complete and clear. That is why the SLC is instructed that DA to obtain the detailed report on the clarification of the aforementioned evaluation and place the same before the next SLC.
No, their father's name perhaps are different.
That will be different. That report has to come from the district. If the district doesn't send the correct Lordship report, that director sitting here is difficult to Lordship analyze. That is the difficult. That is why Lordship, it was again requested the D. Dhemaji.
In the writ petition and the contempt petition, the name of the petitioner has been mentioned
That is it.
along with his address.
Yes.
Then why there is confusion?
strange, your lordship?
Because in the same school, there are two petitioners in the name of Dimbeswar Gogoi.
You were to provincialize the service of the petitioner, present petitioner, not the other person.
Specific direct.
But this way the matters are getting delayed. Court has directed to provincialize the service of the petitioner, Dimbeswar Gogoi, not the other person. Why there is confusion?
Page 27 is the directions, your lordship. Very specific. May I read your lordship. View of the conclusion as this. The director of elementary education, in view of the determination as made here and above, court has already made that the petitioner is eligible and entitled for having his service provincialized as a social studies teacher in the state school, would now place the case of the petitioner before the SLSC for scrutiny of his service particulars, and the director of elementary education Assam, while placing the case of the petitioner herein before the SLSC, shall intimate the committee that the petitioner is working in the state school. And the exercise was supposed to be completed within a period of 120 days.
Sir, 60?
Yes, your lordship.
Why this confusion?
That Lordship, I will have to specifically act from the director, Lordship.
There may be many Dimbeswar Gogoi in a particular district. The direction was to provincialize the service of the petitioner Dimbeswar Gogoi, not of the others.
Pursuant to earlier order, I appeared before the director, filed a representation. That was not considered. Then again, I came, your lordship. So I was known to them. It is not that some other Dimbeswar Gogoi is also claiming something. Why they are? This is the fourth round of litigation. And the order was passed on 34/2024.
heard, Mr. I pray for personal appearance maybe. Otherwise the matter may not be. MS plus for learned counsel court of petitioner, Mr. Assembly 16 learned counsel for the contempt. Mr. Sisley has produced a letter dated 16th October 2025. Addressed to him by the Director of Elementary Education. In view of the order dated, letter dated 16th October 2025, Mr. Sisley is directed to obtain up-to-date instructions from the director and to place the same before the report on 22nd. Principal list the matter on 22nd.
32 and 33.
Here, the office note says the service report is awaited from the private respondent. Last order, office note says that there is a service report is awaited.
Office not dated.
Well, last in the administrative orders, man. The steps has been taken and in 3750/2024.
37.
3750/2024. It know. And this is the document, my lord, that we have taken. That's it. That's it, no?
Respondent number 4 is Nilavati Hazarika.
My lord. Respondent number 4, Lilavati Hatun. Though she is a formal party, my lord. Not that necessary. I think by this time she has retired. My prayer is for retrospective promotion because of the my lord roster system. The subsequent judgment came before this court by a division bench. Well, previously it was different. Now because of this my lord 78 Act, which the division bench in judgment, my lord.
No, that's all right.
IV Gohai Dasgupta, read appeal number 46 of 2023. Previously, it was quantitative data, then it was subsequently changed. Tips law আছে না? Tips law আছে না?
What is the actual name of the respondent number 4? Nilavati or Lilavati?
Lilavati, mas.
Lilavati.
Lilavati.
Wait.
Is in that order, it was wrongly written as Nilavati, but it should be Lilavati.
Okay.
But everywhere it is written as Nilavati. Every other orders also Nilavati. So, my lord, maybe for that reason, my lord.
No, she herself has written a letter to this, to the assistant register, where she has signed as Nilavati Hazarika.
Nilavati.
Nilavati.
Then, my lord, here the name is wrongly written as Nilavati. It should be Nilavati. That is, so there should be an application for correction of the name, man.
Art, sorry. PK Sururi learned a council for the petitioner at Miss
PCA
for respondent number
1 to 3.
1, 2, 3. 1, 2, 3. Mr. Royce, learned counsel for the petitioner has pointed out to the order dated 18/9/2025 of the Lausimak Court, and also the letter dated 11/13/2025, and submits that the name of the respondent number 4 ought to have been Nilavati Hazarika instead of Lilavati Hazarika, and as such, there is a requirement of correction of the said respondent number 4 in the writ petition, and he may be granted some time to file one interlocutory application to make necessary correction of name of the respondent number 4. There is accordingly allowed basis of the matter after 2 weeks.
10 days, my lord, will do. Suffice there. 10 days.
10 days.
10.
Okay. 10.
Obligation.
My lord, as per office note, my lord, service is completed, my lord.
Service completed.
Yes.
Lordship, I am for the respond number 8, Lordship. My name is not appearing in the cause list, but I have signature in the vocal number, Lordship. And also, Lordship, I am for the respond number 7, Lordship. And I appeared before the law, my Lordship, to file the vocal number, Lordship. I was on the impression that the vocal number has already been filed, Lordship. But today in the morning, I discovered that vocal number has not been filed. Lordship, therefore, kindly allow me, Lordship, after vacation, I will file the vocal number for respond number 7.
Third, Mr.
A. Rashid.
Learned counsel for the petitioner, and Mr.
A.K. Ahmed.
A.K. Ahmed, learned counsel for the respondent number 7.
7 and 8.
7 and 8. The learned counsel for the respondent number 7 submits that he will be filing his power by next within 1 week. Within 1 week.
Within 1 week.
Within 1 week. The learned counsel for the petitioner submits that in this petition service already completed, and as the matter may be listed for admission hearing. Accordingly, it is provided that this is list the matter for admission hearing, and this is also reflect the name of Mr.
A.K. Ahmed.
A.K. Ahmed in the cause list.
Lost.
My lord, if they want to file affidavit, in the meantime, they can file, my lord.
The respondent may file their affidavit.
Published.
Obligation.
Lordship, I need a little accommodation in this case. Lordship, may kindly give me some time to get a up-to-date instruction. Lordship.
Heard, Mr.
Amraman.
On
behalf of
for the petitioner, for the contempt act. Such a state submits that he may be granted some time to obtain up to the next year. They are allowed, that's the matter. When?
After 2 weeks, Lordship.
No.
1 week.
After 1 week. After 1 week.
Item 40. Obligation.
May I please? My lord,
Son of the petitioner, he appeared in the class 10 CBSE examination. Out of 5 subjects, my lord, he was declared successful in 4 subjects. He was unsuccessful in science, my lord. Your lordship will find the annexure 3 space 24. D1, D2, it stands for pass. E is a compartmental. Page 24, my lord. Service subject code 86 science, he got only 31. Positional grade is E. E means your lordship will find at page 22, my lord. Page 22, lordship will see. Lordship has got it.
So service completed here.
My lord, service in regard to the principal of the school, my lord. He is a formal party, my lord. Only it is required that CBSE will obtain instruction how the marks was decreased, my lord. He was declared
So
unsuccessful.
you tell me whether service completed or not.
No, my lord, in respect of 4 is not completed, my lord.
Not complete.
My lord. He is a formal party, the principal of the school, my lord.
No, is it not necessary to
My lord,
notice upon him?
my lord, I have taken steps, my lord, but only before the vacation it was served, my lord. Perhaps this is not completed, my lord.
Service is awaited as per this order.
My lord.
Order the laws in my court.
My lord, as regards the respondent of 4, my lord.
Wait for some time.
My lord, only difficulty is that he is supposed to lose this academic year, my lord. The next exam will in the month of February, my lord.
So definitely prior to that day we will.
My lord,
dispose of
what
the-
happened in short, I want to state, my lord. He was declared unsuccessful in science, my lord. He
We
applied
will
for,
not hear you today.
my lord.
First, let notice be served upon all the respondents.
My lord, on the last occasion, standing out till CBSE was directed to obtain inspection. He may,
We have not yet received instruction because it has to come from Delhi.
no, my lord, it is from
No.
regional office Punjab. Region.
We know better.
Yes,
where it will come
of
from.
course, of course.
So actually, we have sent the petition to Delhi. So they're from Delhi, CBSE office it has not yet come.
And if your lordship permits me, we will take steps dusty on this respondent program.
Heard Mr. P. Hazarika, learned for the petitioner. And Mr.
D. Bora, on behalf of Mrs. R. Bora, sending on to ACP.
Your name?
D. Bora, on behalf
D.
of
Bora,
Mrs. R.
learned
Bora,
counsel, appearing on behalf of Mr. R. Bora.
Mrs. R. Bora, CBSE, sending on.
Respondent number 1, 2, and
1, 2, and 3.
1, 2, and 3. Order dated 16/10/2025 of the law in my court indicates that service upon respondent number 4 is still awaited. Mr. Hazarika, learned counsel for the petitioner submits that the petitioner may be allowed to effect service upon the respondent number 4 by the stipend.
My lord.
They are allowed. After effecting service upon the respondent number 4, the petitioner shall file an affidavit before this court. The learned counsel for the respondent number 1, 2, and 3 submits that he has not received instruction. So there was no direction for obtaining instruction.
No, my lord, it was verbally communicated. Ms. Bora, she was submitted before the court that on the next day she will obtain the instruction. By the night.
We have got instructions, Your Lordship.
The learned counsel for the respondent number 1, 2, and 3 is accordingly directed to obtain instruction and place the same before this court on next day. This not
On 7th November,
7. My lord.
highly obliged. Timing item 30.
Obliged.
Again, I will say the DIF school has already written a letter with the clarification on 8/9/2025 to the Director of Pension, and now it is pending before the
Thank you.
It's a every.
Yes, yes.
So the letter submitted to you on 19/11/2024.
Lordship, on earlier instance, Your Lordship, I had
19/11/2024, that letter I have, Lordship. Hey, come here.
Yes, Your Lordship. Lordship, the petitioner has given to me that a communication dated 8/9/25, Your Lordship, which was sent to the Director of Pension, Your Lordship, wherein they have stated that they have sent the communications will take in the 2024. Lordship, on earlier instance, before, prior to 1 or 2 date, Your Lordship, perhaps it may be in record that means I have furnished the instruction that was updated instruction that was available with me, Your Lordship. So there was, the department was asked to obtain the instruction. So now, since the petitioner had furnished me this, that with that letter dated 8/9/25. So, if Your Lordship permits me, may the matter be fixed on next week, Thursday, Friday. I tried to catch them, but they were in the mediation today. So they told me that, since we are in mediation, it's fine. With regard to this matter, the up-to-date instruction I tried to obtain, but they were in here. So with regard to this 8/9/25, let the matter be fixed on next week.
Okay. Further AF at Mata learning product theory. Number 2, that's the assembly system. So that's content number 1. That's content number 1. But okay, subsequently the director of pension is implicated as part. During the course of deliberation, Mr. C has produced a letter dated 8/9/2025 issued by the Deputy Inspector of Schools in Cyber, which indicates that the inquiry was conducted and the inquiry report and all relevant documents and particulars were submitted to the DEE Assam, and also to the Director of Pension Assam, by letter date dated 19/11/2024. So Delhi Learned Council for the contact number 2 submits that it granted some time to obtain status of the initial letter. Query is accordingly allowed, leads the matter on 24th. 24th.
Lordship, on earlier two instances also I prayed before your lordship to reflect my name.
Yeah,
Made
okay,
it
yeah,
to-
whereas it doesn't reflect the name of Mr. Delhi. That's it.
But there is unknown of us.
Right.